So are you in trouble now? I got some nastiness.
I just talked to you and told.
Yeah, apparently we didn't send in our requests. So this was invisible, and that someone didn't like that. And so I apologize. It was busy last week. We had 2 trials going on. All right, let's get started. Ms. Rivers, good morning. Can you hear us?
Yes, I can. Good morning.
Good morning. We're going to go on the record in case 21 SC 177401. It's State versus Landon Christopher. And this is time for the hearing on Mr. Christopher's motion for new trial. I think we've got Mr. Christopher appearing from the Wheeler Correctional Facility. Is that correct?
Yes, sir.
Are you able to hear us?
Yes, sir.
Excellent. All right. Well, if at any point you cannot hear us or there's something that you want to add, wave your hands or something, and it may be they leave you unmuted, which is fine as long as there's not any background noise. But for the most part, Ms. Kuo, your lawyer, will be doing the speaking for you. Ms. Kuo, good morning.
Good morning, Your Honor.
Thank you for joining us. I have here in court Ms. Eaglin, who's representing the state and who filed the state's response. I have Mr. Hurt's original amended motion and then your second amended motion, and we're going to move forward on that. Are you ready to go forward, Ms. Kuo, or is there anything we need to work through before? I have a couple questions for you, but before I dive into the substance of the motion for new trial, is there anything we need to discuss procedurally?
I do have 2 witnesses that I subpoenaed, and I don't know if they're outside the courtroom or not because I'm not inside the courtroom, but I did send them an email. They indicated they were going to be in court this morning, so I don't know if that means because they had other matters that started at 10 but I did send them an email earlier to say, I'm in the courtroom. Are you outside the courtroom?
Okay. Who are we looking for?
Trial counsel in the case. I had subpoenaed Lacey Wood and Lee Feely.
Okay.
And they both told me they would be here today, so I imagine maybe they're outside the courtroom. But I'm
well, we know them. They're familiar faces here. My deputy is shaking his head saying no, but I'm going to have my staff reach out to them as well. I bet they'll be here, but we'll just double check and get them in here, or at least get an update from them as to if they're stuck somewhere. But I can tell you, their only scheduled business would be in my courtroom anyway. So, and we don't have a criminal calendar until 11. So if they said they'd be here, they ought to be here. There shouldn't be anything that's pulling them in a different direction.
okay. I mean, I didn't know what time. I know that Ms. Wood told me that she was, going to be in court with you. I didn't ask what time, but, the subpoena did indicate 9:30, and I believe the emails I sent to them, they understood it was at 9:30. So,
well, we will check on their whereabouts. In the meantime, what would help me before we dive into any of the evidentiary presentation would be if you would let me know what the grounds are that you're going forward on. Mr. Hurt had a rather unique writing style. I'm going to call it almost stream of consciousness. I mean, there is some organization hung around it, but Ms. Wood just walked in. So your first witness is here.
oh, great. Thank you.
But he sort of leaves no stone unturned, and that is an approach that an attorney can take. I don't know that the appellate courts necessarily embrace that, flagging every possible instance when someone could have objected to a leading question and they didn't, that kind of thing. And so I wanted you to summarize for me what you felt the grounds were, not the substance of them so much as the nature of them, because your second amended motion that you filed at the beginning of the year starts with grounds number 13, which tells me you think there are 12 set forth in Mr. Hort's motion. And I don't want to miss anything when I enter my order. I tend not to simply enter an order that says granted or denied, but I engage on each of the grounds. And I think you and I discussed when you took over the reins of this appeal that you were going to review Mr. Hort's filing, and you might adopt some of his arguments, you might abandon some of them, and it would help me ensure that I am writing an order that is complete if you walked me through each ground. So I've got a numbered list, and that way Ms. Eaglin will also know if the state has engaged each of the grounds as well. Does that make sense?
Yes, I understand. Your Honor, when I filed the Second Amendment motion for new trial, I started with claim 13 simply because I was following in the order that Mr. Hort had followed. I mean, I certainly probably could have started with I could have called it number 1, but I just decided to follow in the order that he had prepared it. And at the time, I didn't know which grounds I would adopt or not adopt. I guess I would just say that I'm not necessarily withdrawing any of the claims that he filed, but I may not touch on them during the hearing on the motion for new trial.
So you are maintaining all the grounds. My order ought to, whatever I construe some of his grounds to be, his organizing principle seems to be more the standard of review. And so he'll have a header that says plain error, and then he lists what he thinks the plain error was that occurred in the case, and then abuse of discretion, et cetera. And you are not affirmatively withdrawing any of those grounds. You have added a few, and those are very discernible in a way with which I'm more familiar. And then I guess you're going to amplify the ones that you want to amplify based on either your examination of the witness or whatever ones you choose to seize upon. Is that a fair summary?
Yes, I mean, I guess I don't want to, box myself in by saying I'm not going to raise this or I'm not going to raise that. I mean, I think that it's a fair statement that I'm going to adopt the general grounds that he's raised. And regarding the plain error, I believe he's raised plain error in a number of different ways.
Did, and I only use that as an example. He has his view as to what the plain errors were, and I will do my best to suss them out from his presentation. I just, again, and we don't need to dwell on it more. I have had lawyers who have taken over appellate representation and said, you know what, Judge, we're going forward with number 5 and number 7 from my predecessor, and then my new grounds. That's it. I'm not interested in advocating for or pursuing these other ones, but you are going to adopt all of his, and then you have layered on top of that. You have 1, 2, 3, 4 more grounds.
Well, that's true, Your Honor. He's filed this amended motion for new trial, and I'm not withdrawing it in toto, but if I have the opportunity to make a closing argument at the conclusion of the evidence, then that would make clear which claims I'm actually pursuing.
Okay. Well, let's do it that way.
Based on the evidence and the argument.
Okay, that works for me. Well then, Ms. Eaglin, anything you want to talk about procedurally before we have Ms. Kuo call her first witness?
No, you're all right. Keep with it.
Great. All right. So Ms. Wood is, hold on one second. We've got another prosecutor in here. Yes, sir.
I apologize. Last week, Eaglin extended a request for Ms. Kuo for excused reporting to the case, and I got that just this morning at 9:30.
Okay.
She doesn't need them anymore? All right,
All right.
well, that will conclude my business.
Good work. All right, as you were.
Excuse me for one moment. Ms. Eaglin, please turn on your microphone.
Sure, that was an off the record discussion.
Yes, but her microphone needs to be on as well.
Can you say that again?
Counsel at prosecutor's table, microphone needs to be on.
Oh, Ms. Eaglin, can you make sure that microphone is on? I think, is it a red light or a green light?
It's a red.
Okay, if you can make it green, put your finger in the little well.
Green.
Green, excellent. Now she can hear you. Okay.
Sure. Thank you.
Ms. Wood, good morning.
Good morning, Judge.
Ms. Kuo said that she had subpoenaed both you and Ms. Feely. My recollection was that this was your trial, much more so than Ms. Feely. She may have been seated at the table, but in terms of decisions that were made to call witnesses or not call witnesses, you'd be the attorney of record. Is that fair?
Yes, Judge, I did, and I spoke to Ms. Quo on Friday. There are certain things that Ms. Feely handled in the trial that I think only she could answer. But I've messaged her because I did expect her to be here today.
Great. So, but we could start with you, and hopefully Ms. Feely will be here shortly. Great. So Ms. Quo, hopefully you're okay if we start with, as our first witness, Ms. Wood. Ms. Feely's on her way, but Ms. Wood is here now.
Do you wish to begin, not knowing that Ms. Feely is on her way or is here presently?
I do. I know that Ms. Feely's on her way. Ms. Wood just explained that Ms. Feely's on her way. So I'd like to get started with your examination of Ms. Wood. I just want to make sure you're okay taking them in the order of Wood first and then Feely.
Yes, that's fine. And just an additional preliminary matter. I do wish to renew the motion for bond pending appeal, and do wish to make a brief argument about that at the conclusion of the hearing.
Okay. I'm going to rely on you to remind me about that when we get to the end of the hearing. You can bring that back up.
Okay. Well, I would just waive opening, and then obviously I would also invoke the rule of sequestration in the event Ms. Feely arrives during Ms. Wood's testimony.
All right, I will kick her out if she walks in the room. She can go into the jury room, and we'll get her. I need to add a device here, so hold on one second, because we'll have Ms. Wood go up to the witness stand, but that is not currently on. Witness, here we go.
Was Mr. Armstrong in here for this case or something else?
He brought some videos, but Ms. Eaglin explained that you all had already sorted that out. So he was late to that news.
Oh, so it doesn't relate to this case? I didn't quite hear you.
He brought some videos that you had requested, but Ms. Eaglin said you already got them.
Right, yes, thank you so much.
You bet.
Your Honor, I requested that he come back because he is the one that initially had this case, and he represented the state on the bond argument. He also filed the response. I was not under the impression that that would be an issue that would be discussed today.
The bond?
Argued. Right.
You will be able to handle the bond discussion.
Okay.
If he comes back, that's great, but I'm confident you'll be able to handle the bond discussion. All right, Ms. Wood, if you would come to the witness stand, please. I'm going to swear the witness in because whatever deputy coverage we had just walked out. Oh, there's someone. Do you mind swearing the witness in?
My name, you solemnly swear affirm that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth that you got.
I do.
All right, state your first and last name for the report.
Lacey Wood, LaciWood.
Good morning, Ms. Wood, how are you?
Well, thank you.
And what is your occupation presently?
I'm an assistant public defender for Fulton County Public Defender Office.
And how long have you served in that capacity?
Since the end of 2018.
Okay, can you Describe your legal experience upon graduating from law school.
I was barred in 2017, so I have right at 6 years of experience.
And is this your first, did you have another job before you started working at the Fulton PD's office?
I did. I worked as a assistant public defender in Carroll County.
Was that for state court, Superior Court?
It was Superior Court.
And how many trials did you conduct to verdict there?
0.
All right. What types of cases did you handle there?
Everything but all felony cases except murders and rapes.
Did you serve as second chair to any trials there?
I served as second chair on a murder case there and also on an armed robbery there.
And was a verdict reached in that case?
Yes.
So you began working in the Fulton PD's office in July of 2018. Did you begin your experience there in a certain rotation, or did you start in a certain courtroom or certain division?
I was hired in Fulton County at the Public Defender's Office. I believe it was December 2018. And I worked in the non-complex division, handling felony cases that are mainly drug offenses and property crimes. And I was promoted to the complex division in July 2021.
Okay, so in the non-complex division, does that involve any jury trials?
On paper, they say they have jury trials, but in reality, no.
All right, Ms. Cole, we're going to pause for 1 second. Ms. Feely just arrived. You can be in the jury room or out there, wherever you're more comfortable. We'll get you when it's your turn. But Ms. Cole did invoke the rule of sequestration, so we don't want you polluted by what Ms. Wood might have to say. So just let me know which direction you'll be, and we'll get you.
Into the hallway.
Hallway it is. Okay, thank you. All right,
Thank you.
Back to you, Ms. Cole.
Yes, thank you for that notification, Judge.
Sure.
So when you began in the complex division in July 2021, what types of cases did you handle there?
I handled, starting off, I handled everything but rapes and murders up until about 2022. I started handling murders and rapes.
Okay, so up until 2022, or let's say prior to this trial, prior to Mr. Christopher's trial, how many felony jury trials had you conducted to verdict?
1.
And what type of case was that?
Aggravated stalking, and I believe it had a simple battery attached to it as well.
Was that before Judge McBurney?
Yes.
So were you the initial attorney that was appointed to represent Mr. Christopher in this case?
No, he had attorney Devin Franklin from my office before I came into this courtroom, and before that, he had a private attorney on the case.
Okay, so the private attorney filed a motion for bond and obtained a bond for Mr. Christopher.
I believe that's correct.
And when you met with Mr. Christopher, you would meet with him in your office?
Yes, I met with him several times in my office because he was out on bond at the time.
And did you get the file from Devin Franklin?
Yes.
Did that include all the discovery?
Yes. I do
And-
believe there were, I'm sorry. There was some media, like I believe it was crime scene photos that the prosecutor at the time had to resend to me, but otherwise everything was in the file.
Okay, so you had everything you needed in terms of the discovery prior to trial?
Yes.
You didn't have to file any additional motion to get something that you didn't already have?
No.
Okay, so did you have an opportunity to meet with Mr. Christopher and get his side of the story?
Yes, we met a couple of times in my office and we spoke on the phone quite often.
Okay, did you send him the discovery? Or review the media with him?
Yeah, I'm not sure if I made a copy for him, but I know he was in my office reviewing discovery several times.
And did I provide you a copy of the amended motion for retrial and the second amended motion for retrial in the case?
I know you provided me the one from September. Is there an additional one?
Yes, I filed a second amended motion for retrial.
Thank you, Judge.
She has a copy in front of her now,
Yes.
but she's going to give it back when she's done.
Okay.
You're welcome.
So the documents that the judge just gave you, what did he show you?
The second amended motion for new trial?
Okay, is that something that you have seen before?
Yes.
Okay. And you said you also received a copy of the amended motion for new trial filed by Mr. Hort?
Yes.
He provided that to you early on in the case when he was representing Mr. Christopher?
Yes, and I believe you sent me a copy as well.
Okay. So in this case, were you lead counsel?
Yes.
Mr. Christopher, was he your client?
Yes.
And if you could just briefly tell me what the discovery from the state consisted of.
Sure. There was a hit and run accident. A gentleman was walking home. It's late hours. He had been working. I believe he was working at a tavern. He was walking home from work. He was hit by a car. He had a broken ankle, if I remember correctly, and I think maybe a broken cheekbone or jawbone. He had a couple of injuries, and he was left on the side of the road after the collision. There was a 911 call made. The first responders responded to the scene. They found parts of a vehicle there. And then the very next day they received, I believe it was their next day, after the fact, they received a 911 call saying there was a vehicle sitting in a church parking lot that had sustained damage.
Okay. I think I appreciate that. I appreciate that you recall the facts of the case. I guess my question was, what did the discovery consist of?
Oh, I'm sorry.
No
It
worries.
was, I'm so sorry. There were a lot of photos. There were body cameras, 911 calls included, the police incident report. Medical records were turned over at one point. Yeah, lots of photos from the crime scene.
Okay. And so do you also had the incident reports
Yes,
and the supplemental reports?
yes,
And did you have ample time to review the discovery prior to trial?
yes.
And at what point did Ms. Feely become involved in this case?
I remember asking her to come to my office and sit in and review the discovery with me and speak with Mr. Christopher as he was coming into my office for a discovery review session in May of 2022. And that's the first time that she interacted with the case. And then I believe she may have spoken with him another time. It was on a trial calendar before it actually went to trial in that December. And then, of course, when we realized it was going to be a trial, she got involved.
So did you ask her to sit as second chair with you?
Yes.
Or as technically, or for as lead counsel, or please explain to me her role in the case at trial.
Sure. So she is the senior trial attorney in this courtroom. She has tremendous experience trying cases. She was my mentor at the time. She still is my mentor. And so when we realized that it was not going to resolve short of trial, she began speaking with Mr. Christopher about options. He had a good rapport with her, I felt. And so she was always going to be the second chair in this case. And then as it progressed, there were certain elements that I felt more comfortable with her handling. So that's why she handled certain witnesses and made certain objections and handled the charge conference.
Okay, so prior to trial, did you prepare the written request to charge?
Yes.
And do you know if Ms. Feely reviewed that?
I don't recall if I had her review my charges before this trial.
Do you know if you prepared those charges after the plea deal fell through? Or were they submitted like in advance for some reason?
I believe, let's see, the plea fell apart on the Thursday. The charges would have been probably due on Friday. So probably after the plea fell apart.
After the hearing on the motion to enforce the deal?
Yes.
Because the court ruled right away on the motion.
I believe so.
Okay. So in your excuse me, in your review of the discovery and in both in writing and the video discovery, the media discovery, did you feel like there was a basis to file a motion to suppress evidence challenging the search and seizure of Mr. Christopher's Highlander?
I did not.
Okay. Did you feel like the law enforcement officer had the authority to seize his Highlander, take it from the scene when they did not arrest him at the scene?
When you say scene, just so I'm remembering, was it the case, Ms. Kuo, from your review of the record, that the scene is a church parking lot, not where this individual was hit?
Yes. Thank you so much, Your Honor.
No, I'm not correcting you. As I'm thinking through what I'm going to need to do, my recollection was the Highlander was parked in a church parking lot, didn't have a connection with a church parking lot, so arguably was an abandoned vehicle. It wasn't sitting at the side of the road with Mr. Christopher standing next to it saying, "Hey, what are you doing? This is my car," or "It's my girlfriend's car."
That's correct.
Okay.
Yes. Thank you.
Nope.
So
Good.
I'll just ask my question again. So based on the evidence that was in the discovery, the fact that Mr. Christopher's car was in a church parking lot, and I believe the officers testified at trial, and perhaps this evidence was also in the police report, that he was not arrested after they met with him at the scene. After he made the 911 call and the officers came out and talked to him, he wasn't arrested at that time. Is that right?
I believe that's correct.
Okay. And so after he left, apparently the law enforcement officers, they decided to seize the car for their investigative purposes and also later searched it or took photographs, things of that nature. Did you feel like there was a valid basis for the law enforcement officer to impound the car or take the car when it was without his consent and they had not applied for a search warrant? Did you feel like there was any exception to the warrant requirement that applied in this circumstance for that to authorize them, to justify them to seize the car and search it?
Yes, at the time, I didn't see a viable motions issue, so that's why I didn't file one.
And when you said you didn't see a viable motion issue, could you explain that in more detail?
Well, I didn't think that there was a basis to file. I think, correct me if I'm wrong, I thought that he was still at the scene when it was seized, but is that not correct?
Well, you're not forced to recall. I mean, the record is going to be what the record is. He was there, he wasn't there. But your testimony is you didn't see a basis to file it. And I guess rather than have Ms. Wood comb the recesses of her memory about the wherefores of that. If you've got specific questions like, did you not think there was this basis or that basis, Ms. Quo? I mean, I think that'll be, I will not view that as leading. It will get us to your points you're trying to make with this witness.
Sure. Well, I mean, that's fine. I mean, I think that, you know, given the fact that she did review the discovery prior to trial and, you know, based on the facts and circumstances of the case, I won't harbor the point, but I guess I'll just ask whether you felt like there was a valid basis for the officer to impound the car and seize it at that.
Yes.
Yes. Okay, and what was the reason for that?
It was, at the time, the officer believed it was part of a investigation.
Okay, and did Miss Feely ever speak with your client outside of your presence prior to trial?
No,
And prior to trial, did you ever explain to Mr. Christopher that he had a state and federal constitutional right to be present at all critical stages of his trial?
I do not remember having that conversation.
Okay. Did you ever explain to Mr. Christopher what a critical stage of the trial was?
I don't remember having that conversation with Mr. Christopher.
Okay. What was your defense theory in the case?
That Mr. Christopher was not the one driving the vehicle.
So prior to the trial, when it became evident that Ms. Kayla Newborn was going to be an adverse witness to the defense, was there a reason that you did not submit a written request to charge on accomplice corroboration?
No.
And was there a strategic reason that you did not submit a written request to charge on, I believe there's a pattern charge that covers immunity or leniency granted to a witness?
No.
Do you believe that was just oversight on your part?
Yes, probably.
Did you have a discussion with Ms. Feely about those charges, whether or not they should be requested either prior to trial in a written form or orally during the charge conference?
I do not remember having that conversation with Miss Feely, so no.
And when you entered the phase where the court wanted to discuss the charges in the case, did you have a conversation with Ms. Feely prior to that point in time that she would be the primary attorney to answer the judge's questions regarding certain charges unless the judge were to address you directly?
Yes, I specifically asked her to handle the charge conference.
And at what point did you ask her that?
Early on, I mean, it was, you know, a day or so before the charge conference.
Okay, so it's after trial, but before.
Correct.
Okay. Do you recall at the beginning of the trial that the judge made the attorneys aware? This is like during jury selection. Do you recall that the judge made the attorneys aware of the fact that his staff attorney had excused juror number 41 due to some sort of illness on that juror's part? Do you recall that occurring at all?
Not specifically for this trial, no.
Okay. So after the judge excused that juror, did you have any type of conversation with Mr. Christopher about the legal effect of the excusal of that juror outside of his presence?
I do not remember having that conversation.
Was this, and I'll dive into the record, Ms. Quo, at the appropriate time, but is your understanding that juror 41, this was during jury selection? This wasn't a juror who was on the jury and had heard 2 days of evidence, and then without telling anyone, I told that person to go home?
Right. It was on the first day of trial. It was when it was early on.
Okay.
It's on page. Yeah, it's early on.
Okay.
It was the excusal of a juror by your staff attorney. You had indicated to the attorneys that your staff attorney, you didn't get a chance to tell the attorneys, but your staff attorney excused this juror. That's what you said, essentially.
Got it. Okay.
So just based on your legal experience, the fact that you were barred in 2017, I guess that would mean that you are not really familiar with cases tried under the old evidence code. Is that right?
I am not, no.
Okay. Were you aware of what the pattern jury instructions looked like under the old evidence code?
I'm sure I've seen them in passing, but I'm not familiar with them.
So you didn't ever have the opportunity to try a case or observe a case that was tried under the old evidence code?
No.
Do you recall during the charge conference, there was a point in time where Pierre Hand asked the court, oh, I want you to give a charge on prior consistent statements. Do you recall that at all?
I do not.
You said you reviewed the body cam footage prior to trial of the police officers. Is that right?
Yes.
Okay. Do you recall there was, and the body cam footage was played during the trial?
Yes.
Is that correct?
Yes.
Right. Do you recall when the body cam footage of various officers was played, there was, it contained an officer, and I believe it was Sergeant Fortunato's comments that, he was calling my client a son of a bitch, and either he or another officer was basically saying that he didn't believe him, he didn't believe him about the story that he was telling. Do you recall seeing that or listening to that when you reviewed the body cam footage prior to trial?
Yes.
So was there a strategic reason that you did not move to redact that comment from the body cam footage prior to trial or object to that publication?
I do remember we had a discussion outside of the jury to keep that out. I don't remember the ruling, but I do remember having that discussion to keep it out.
And did the court exclude it to your understanding?
I really can't remember.
Okay. And when you said you had a discussion with the judge outside the presence of the jury, was it also outside your client's presence, or was it just outside the jury's presence?
Mr. Christopher would have been at the table.
Okay. And during the trial of this case, was there ever any time where initially everyone was in the courtroom, but then for whatever reason, the judge said, I want to talk to the attorneys in the back in chambers, at which time Mr. Christopher was not present for any discussions about the case? Do you recall if there were any in-chambers discussions?
No.
So regarding Miss Feely's role, you said there was some division of labor there where you handle certain witnesses before trial, or you decided that you would handle certain witnesses and she would handle other witnesses. Is that correct?
Yes.
And would it be fair to say that she was an active participant in the trial?
Yes.
And she represented Mr. Christopher in a full capacity, just like you did?
Yes.
During the trial, do you believe there was any time where Ms. Feely spoke with your client outside of your presence?
No.
Your Honor, just if you could give me a minute.
Not a problem.
Do you recall there being like during the trial of the case, there was some during the examination of one of the police officers, there was some issue being made about whether Mr. Christopher had the only key to his car?
I do remember that issue, yes.
Was that like a relevant issue for you as his attorney?
No.
Well, so it wasn't important to his case or your representation of his case about whether he had the only key or not?
I believe the key issue was in the church parking lot, so at that time, no.
Okay, so was that like not within your scope of your was that witness not your responsibility? Was that Ms. Feely's witness?
Since I don't recall much more about it, it could have very well been Miss Feely's witness.
Okay. And prior to trial, you did there was a plea offer made in the case, or could you describe the plea offers that were made in the case?
We had several prosecutors on this case. There may have been an offer made when Mr. Franklin had the case. I don't recall what it was. I do know right before the trial, there was a misdemeanor offer on the table that we accepted, and then it was taken back. And so we had a motion to enforce the deal, but I don't know, I can't remember any of the other specific offers that were made.
Okay. And so your client, you did receive a plea offer from the state to plead to count 2.
Yes.
And that was accepted by your client.
Yes.
And then subsequently, later that morning, the state revoked that.
Correct.
Okay. And that was the subject matter of a motion that you filed with the court.
Yes.
And you litigated that, argued that before Judge McBurney.
I did.
Okay. And prior to that point in time, there was no evidence in the discovery where she had made any statement that was inculpatory of Mr. Christopher, correct?
Are you talking about Kayla?
Kayla, yes, I'm sorry. Had Kayla made an inculpatory statement in the discovery against Mr. Christopher?
I don't believe so.
Okay. And the whole basis for the state to offer you the plea was because he said there was no evidence on the hit and run. Is that right?
Yes.
Okay. And when Kayla testified at trial about the fact that, well, let me ask you this. Were you aware if Kayla made any written statements, gave any statements prior to trial after the plea offer fell through that could technically constitute improper 404B evidence?
I believe there was a written statement by her after the plea was, or after the offer was revoked by the state.
And what did that written statement consist of?
I don't recall. I remember after it was revoked, they had sent, I believe, text messages and a written statement from Kayla.
Okay, well, the text messages, that was introduced at trial, right?
I believe so.
Okay, as far as Kayla's testimony at trial, do you recall where she made some statements about how she was scared of Mr. Christopher and he had, I don't know, either threatened to kill her or had described where he had threatened other people or, some sort of intent to kill other people? Do you remember that sort of testimony coming out through her?
Yes, I do.
Okay. Was there any reason that you failed to, was there any reason for not objecting to that type of evidence on character grounds or improper 404B that had not been properly noticed prior to trial?
You'll have to ask Miss Feely. That was her witness.
Okay. So you had not received anything in the discovery prior to trial that she would make some statement to that effect. Is that correct?
Correct.
So I think you said early on in your testimony that you did ask Ms. Feely to sit in on a discovery session with you and your client and ask her to review the discovery.
Yes.
So did she review the discovery prior to that meeting with Mr. Christopher and you, or do you think she did that after the meeting or just prior to trial?
No, I had her come to my office and it was just the two of us and we went through it. And then Mr. Christopher came in later for the meeting with the three of us.
Okay, so when you met with Ms. Feely to review the discovery before your meeting with Mr. Christopher, how long did it take y'all to go through all the discovery for her to review it?
I don't remember because I know I wouldn't have played every single body camera for her. But we probably spent an hour or so going over, the major stuff like the police report and the photos and 911 calls.
Okay, so you didn't know of all the discovery in the case, it probably takes more than an hour to review all of the media and the written reports and things of that nature, 911 calls, everything else. And
Yes.
okay, so she just reviewed some of it, not all of it.
Correct.
Okay. And are you aware of whether she reviewed the balance of the discovery prior to trial that she did not review in the office with you?
I do remember sending her discovery prior to trial so that she could be more familiar with it. So yes,
Okay, so you sent it to her, but do you know whether she reviewed it or not?
you'll have to ask her.
Okay. So I believe you said that the defense theory was Mr. Christopher, he was not the driver, but Kayla was the driver.
Yes.
Okay. So during the charge conference, I believe I don't know if you recall this or not, but do you recall you were present during the charge conference, right?
I was.
Do you recall a colloquy between Judge McBurney and Lee Feely where he said, this knowledge charge, I don't think this really applies because, I think knowledge has more to do like maybe with a drug case and, maybe, actual, maybe constructive possession, maybe something like that. And I just don't think it applies. And do you recall that?
I don't recall that specific conversation. So you might need to ask Ms. Feely more about that one.
Okay. So you submitted a written request to charge on knowledge. Is that right?
I did the charges, yes.
Yes. And one of those charges included knowledge.
Sure.
Are you agreeing? Is that true?
So we have a deadline to submit our draft of jury charges on a Friday before a jury is picked on a Monday. And then when we file those, we have the ability to amend those as the trial progresses. So generally what happens is I file my jury charges on Friday, and with the understanding that I'm probably going to change those. And then, so when this trial progressed, Ms. Feely got more involved. And so any discussion or any decision to remove that charge would have been something that she did.
Okay, so prior to trial, did you believe that knowledge is an essential element of hit and run?
Yes.
So when Ms. Feely agreed to withdraw that charge, is there a reason that you didn't object?
No.
Is there a strategic reason for not objecting to the court saying, I want to take this charge out of the out of the jury charge?
Not that I recall.
Okay. So when Ms. Feely said that she agreed with the court to not that she didn't need that charge, why didn't you pipe up and say, well, knowledge is an essential element of hit and run?
I don't know. Oversight on my part.
Okay, thank you. I have no further questions, but I would ask that she not be excused in the event that I need her later.
Let's see if Ms. Eaglin has any questions for Ms. Wood. Make sure your microphone's still on.
Testing.
All right.
Your Honor, I'm sorry. May I take a brief moment to charge my laptop? Just plug it in.
Sure.
Plug in. Thank you.
Mr. Armstrong is back. Can he go? Does he need to stay? You're welcome to stay.
Yeah, his purpose was just for the
Yeah, I
bond.
told Ms. Eaglin she is going to be able to handle the bond issue, no problem.
Thank you very much.
You bet.
Your Honor, is it okay for me to begin?
Let's wait till Ms. Kuo reappears on the screen. I don't know if she had to leave the room or something to plug in the laptop, but when we see her, there she's back. All right. Yes, please. Let's begin.
Thank you, Your Honor.
You bet.
Alrighty. Good morning, Ms. Wood. How are you?
Good morning. I'm well. Thank you.
Okay, I'm going to start out by asking you some very general questions, and then I will do my best to address some of the more specific claims that were raised. So bear with me if I'm a little bit of everywhere. All right. You testified that you were admitted to practice law. Did I hear you say in 2017?
Yes.
Okay. At the time you tried this case, or it looks like this case was tried December 2022. Okay. At the time you tried this case, you had been roughly practicing for what, 5 years?
Yes.
Are you admitted to practice in any other states?
No.
What was your nature of practice at the time that you tried this case? Was it mostly criminal, civil, both?
All criminal.
All criminal. And how many defendants at that time had you represented where trials were reached, where a verdict was reached in the trial?
Here in Fulton, one.
One, prior to this case.
Yes.
Okay. And how many of those trials were felony?
It was felony.
Just that one?
Yes.
Okay. And then do you mind telling me just what the nature of that trial was? Was it another hit and run, or was it?
It was ag stalking. She already told
Stalking.
us.
Okay. Alrighty. Let me ask you this. It seems from your testimony that Ms. Freely was your mentor, and you went to her regarding this case a lot. Were you lead counsel, or was Ms. Freely?
So I was lead counsel in this case.
Okay.
However, I'm the junior attorney in this courtroom. She's the senior attorney. And so at that time, I felt more comfortable with her helping me with this case.
So who had the authority to make all of the final decisions in this case as it concerns just legal strategy?
I did.
Okay. Alrighty, and so I'll circle back there. Okay, so in preparing for this case, can you recall how many times you met with the defendant? I know you said you met with him often, but can you give me an estimate?
So we had many phone conversations. I want to say, I know it was at least twice in my office. I really feel like it was at least 3 times in my office, but 2 for sure.
At the time that you represented the defendant, was he out on bond the entire time?
He was.
Okay. And you thoroughly discussed the case with him?
Yes.
Did you thoroughly investigate the facts?
Yes.
And did you, outside of Miss Freely, have any assistance of others in this case? Any interns, third-year practice act, law school students?
No, I have an investigator on my staff who did some legwork in the case, but no other lawyers were involved.
Okay. Do you recall if your client was able to name any helpful witnesses?
No.
If he would you have tried your best to contact those witnesses?
Yes.
Do you recall at what time, in this case, you filed your entry? Was it after arraignment? Was it during pretrial motions? Can you gauge?
It was after arraignment, probably July 2021 is when I came into this courtroom and would have taken over this case.
Okay, and you testified that prior to you becoming counsel, there was another public defender on this case, and there also was a private attorney. Had the pre-trial motion stage, do you recall if that had already taken place, or were you responsible at that point for all of the pre-trial motions?
I believe everything outside of motions in limine would have already been due. I think this case was arraigned early 2021. And so it's my recollection that the deadline would have been passed.
Okay, and you had an opportunity to review things that had already been filed?
Yes.
Okay. Had there been anything that was not filed that you felt needed to be filed, that was beneficial to this case, would you have done so?
Yes.
Okay, I want to briefly talk to you about the vehicle in this case. You testified that you took this case after arraignment, but it was prior to pretrial motions, but that you reviewed the evidence. With that being said, at the time, do you believe there was a factual or legal basis for there to have been a warrant in regards to the vehicle?
At the time, I felt like law enforcement on the scene were lawfully seizing the vehicle.
Okay. And so had you thought that this was problematic, would you have raised that at this stage?
Yes.
Pre-trial? Okay. Do you believe that the car being seized, had you raised it, would that have been something you think that you would have likely prevailed on?
No.
Okay. Okay, and The defense in this case was that the defendant was not the driver, correct?
Yes.
At the time, do you feel that this was the most reasonable defense?
At the time was, yes.
Were
Did
there
you-
any other reasonable defenses out there that you could come up with?
No, Judge, I don't know that.
Okay.
Can you briefly tell me what you did in this case to pursue evidence to establish that the defendant was not the hit and run driver?
Outside of attempting to speak with the other person involved, I don't recall doing anything outside of that.
So let's talk about that. Did you have an opportunity to, excuse me, to speak with Miss Kayla Newborn?
I never personally spoke with her.
Okay. Well, I can ask Miss Freely that. Is it customary for you to try to speak with the state's witnesses?
I generally have my investigator speak to them.
Okay, do you recall if your investigator tried to speak with Miss Newborn in this case?
I can't say for sure, but I know that I would have asked him to have at least an attempt to speak with her.
Do you believe that conversations with Miss Newborn would have been beneficial for your client?
It's always beneficial to have an idea of what witness is going to say on the stand, so yes.
Okay, on cross-examination, you questioned Miss Newborn in detail about her testimony of being fearful of the defendant. Can you tell me what was your purpose in doing that?
So Miss Feely handled that witness, so you would need to ask her that question.
Okay. Okay, you testified that you do not recall having a conversation with the defendant about his right to be present during critical stages of the trial. Would it be customary for you to have had that conversation with him?
So I always tell my clients what to expect at trial, but I would not have broken it down. I don't remember ever breaking it down into critical stages for him.
But that was something that you, as an attorney, was aware of, were his rights.
Yes.
And knowing that, would you have done your best to protect his rights in that way?
Yes.
Okay, in reference to the accomplice corroboration charge, you testified that not requesting the charge was an oversight on your behalf. You also testified that you don't recall speaking with Ms. Freely about this. Ms. Newborn was not charged as a co-defendant in this case, correct?
Correct, but there had been conversations leading up to trial that she may have been added if state got their way.
Okay, based on your knowledge of law at that time, do you believe that the evidence supported the giving of an accomplice corroboration charge?
Can you ask that again? I'm sorry.
Based on your knowledge of the law at the time that you tried this case, do you believe that the facts and the evidence that was presented in this case supported the giving of an accomplice corroboration charge?
Yes, probably so.
Okay. So if you thought that, please explain to me why you thought that an accomplice corroboration charge in a case where there was no charged accomplice was appropriate.
She was at the scene with Mr. Christopher. She made statements to the officers at the scene. That's the main basis.
Okay. Do you believe that this charge not being given was harmful to your client? And if so, please explain.
I would object. That's a legal question for Your Honor.
I think that she's the attorney that represented the defendant in this case. The question was posed why she failed to give the charge. So I think her state of mind is very relevant to us understanding why she failed to give the charge.
So I've got a couple thoughts on that. I see Ms. Quo's point, but I think this is more a Ms. Feely question.
Okay.
I know Ms. Quo pressed Ms. Wood about why didn't you tell Feely to change her mind? My understanding of the dynamic of the charge conference was that while Ms. Wood was present and actively listening, it was Ms. Feely's show. And so let's explore with her her thoughts on the accomplice corroboration charge.
Yes, Your Honor. Okay. You testified that when you file your charges, it's done with the understanding that you could possibly later amend them, correct?
Yes.
And you also testified that you believed knowledge was an essential element of the charge of hit and run. Can you expand on that?
That's what I thought, and any oversight not to speak up at the charge conference is solely on me.
Do you believe that the charge, not the knowledge portion of the charge not being incorporated, do you feel that that was harmful to your client?
I'm not sure.
I would object. I would object. That's a legal question for the court. You know, what she thinks or doesn't think about that is really not relevant. It only depends. Yep.
She's answered she wasn't sure, so that's a neutral enough answer that I don't think it's a problem. But we'll keep moving.
Okay, moving along. Okay, let's briefly talk about the body cam footage. And some of the statements that were made by the officers. Do you recall whether you objected to, and I believe your testimony was yes, but I just want to re-ask, do you recall objecting to certain statements that were made on the body cam footage being kept out?
So there was an objection. There was a whole conversation between defense counsel and the state and the judge outside the presence of the jury to keep those statements that you're asking about out. So yes, there would have been an objection.
Okay, and for purposes of this question, I am referring to the comments that you were questioned about, because there were a lot of objections made in reference to the body cam footage. But in terms of the specific question that you were posed by Ms. Quo regarding a statement, do you recall filing any sort of motion in limine regarding any specific statements, or was it all just oral?
I don't remember filing anything. It was oral, I believe.
Okay. In terms of just the statements that were made, if you came across any statements in that body cam footage that you felt were inappropriate or harmful to your client, would you have objected?
Yes.
And is it fair to say if you didn't object that you maybe just didn't think it was harmful at the time?
That, or maybe I wasn't paying close enough attention and didn't hear it.
Okay. In reference to the plea offer in this case, is that something that you more so handled or Miss Freely?
That was all me.
Okay. And so you would have been the person that filed the motion to enforce the deal, I believe, correct?
That's correct.
Okay. Based on your understanding and knowledge of the law at that time, do you feel that the state was allowed to try to withdraw their plea at that time? Their plea offer?
No, because we had already accepted in writing.
Okay, Your Honor, I think that this may be all of my questions in regards to Ms. Wood. I think the rest are going to be more so for Ms. Freely.
Okay. All right. Ms. Quo, do you have any redirect for Ms. Wood?
Yes, I do, just briefly, Your Honor.
Okay.
So I know you indicated that your client's defense was he wasn't the driver. But if the evidence at trial, bore out other defenses that supported his innocence, those would technically also be encompassed in his overall defense, correct? For instance, if Ms. Kayla Newborn made prior inconsistent statements at trial, you would be arguing that, she was not a credible witness and should not be believed.
Yes.
And in your mind, at the time of trial, technically Kayla Newborn was an accomplice because she was someone who was at the scene with Mr. That she was, in the car with him, and she did not stop and render aid to Mr. Duffy, right?
Correct.
So whether someone is a driver, or whether someone is the passenger, the person who is charged with hit and run must know that the car collided with a person, right?
Yes.
And there was some evidence in this trial that from Kayla Newborn's cousin, where do you recall that Kayla told her cousin that they thought they hit a deer that day?
Yes.
Okay, thank you. And just real briefly. I think you indicated earlier that the reason you didn't pipe up and object when Ms. Feely agreed to withdraw the knowledge charge, that was based on oversight. Is your answer the same with respect to at the conclusion of the jury charge, when the court did not charge on accomplice corroboration? Was it oversight on your part for not asking the judge to charge accomplice corroboration?
Yes, that would have been my mistake.
All right, thank you.
All right. Thank you, Ms. Wood.
This is just subject to recall.
Right. Okay. Do you mind getting Ms. Feely? All right. We're going to send Ms. Feely in. We will, Ms. Quo, I'm assuming your examination of Ms. Feely will be a little shorter. It doesn't have to be, but I'm just looking at the clock in my courtroom that's filling up. I
That's correct.
probably underestimated the amount of time we'd need for Mr. Christopher's motion. So we'll go for a little bit longer, but I may need to pause or reset us for part 2 of the hearing, depending on how much more we've got.
What time are you starting your other 11 o'clock?
Well, it's supposed to start at 11. I'm gonna let this go a little bit longer because we've got you, and more importantly, we got Mr. Christopher, which means the Department of Corrections has taken time out of their day to set up this video link. So let's see if we can at least get through Ms. Feely's testimony, and she's here now, so she's going to come up to the witness stand.
Okay, great.
And then if all that's left is argument, that's an easier thing to schedule because everyone can zoom in for that.
Okay, I understand. Thank you so much.
All right, Ms. Feely, if you come on up, please.
Maybe excused for a few minutes.
Yes, sir.
Raise your right hand. You swear affirm that testimony will be able to keep the truth.
I do.
I'll say this with the name of the record.
Lee Feely, F as in Frank, Eeley, Lee Lee.
All right, make sure you lean into that microphone, use that chair with no wheels so Ms. Rivers can hear you. You can bend the little microphone knee part down towards you. Okay, Ms. Quote.
Good morning, Ms. Feely. How are you?
I'm well, how are you?
Thank you for coming today. Did you have an opportunity, did I send you a copy of the amended motion for new trial and the second amended motion for new trial in this case?
Yes, ma'am.
Did you have an opportunity to look at that
I did.
prior to trial, prior to now?
Yes, ma'am.
Okay, thank you so much. Could you just state what your occupation is
I'm an assistant public defender for Fulton County.
and how long have you served in that capacity?
It'll be 2 years in April, or in May.
2 years in May. So that started, let's see, May 2022.
Yes.
Okay, so approximately 6 months before Mr. Christopher's trial.
Yes.
Okay, and when did you first meet Mr. Christopher?
I remember him coming into the office for an office meeting, but I don't remember. It was well in advance of trial, but I don't know.
Okay,
Exactly.
so Lacey asked you to join her for a meeting with Mr. Christopher at the office?
I believe so.
Okay, and just real quickly, how long have you been practicing law?
It'll be 15 years I was sworn in November of 2009.
Okay, and can you describe your legal experience upon graduating from law school?
Yes, I started as under the Graduate Practice Act in August of 2009, and then at the Conasauga Judicial Circuit Public Defender's Office, and then worked at the DeKalb County Public Defender's Office starting in 2012.
Okay, and when you were in Conasauga, was that, geez, that's in what, Murray County, or no, that's
Murray and Whitfield, yes.
Whitfield, okay. And what did you do there?
In the rural counties, you get a lot more experience kind of sooner. So I was trying, I believe I tried, or at least picked a jury on a felony case, like in November of being barred. So pretty
So
quick.
how many jury trials had you conducted to verdict in Conasauga?
I think to verdict just one.
Okay, and what kind of case was that?
That was a robbery.
And then you moved to DeKalb County in 2012? And
Yes,
how
ma'am.
long did you work there?
9.5 years.
Until 2020?
22.
Before. Okay, so that was your job immediately preceding this one?
Yes.
Okay, and how many jury trials had you conducted to verdict there?
Probably 25 to 30.
Okay, and some of those cases were under the old evidence code?
I believe so, yes.
And what kind of cases were they?
I tried several in state court, so DUIs and domestic violence mostly, and thefts. And then I was in just a regular courtroom doing just any felony in Superior Court, and then I transitioned into doing just crimes against children. So the worst of the molestation and child death cases. And then I was also the consultant and sat second chair with people for those types of cases.
Okay, and had you tried a hit and run before this case?
I don't believe so. If so, it would have been in state court. Would have been a misdemeanor.
Okay. So do you recall if you spoke with Mr. Christopher prior to trial by yourself without Ms. Wood being there?
Not that I recall.
Okay. And did you review the discovery in the case
Yes.
before trial?
Yes.
Ms. Wood sent it to you?
I believe she probably would have sent me the link.
And do you think you reviewed it a little bit before you met with Mr. Christopher at her office that day?
I know we had talked about the case. I don't know if I'd read the police reports or anything like that at that point, but I know she had gave me a summary before we met with him.
Okay. Were you aware there was a plea offer in the case?
I was aware of those. I wasn't involved at all at that point in those discussions, but I was aware there was a plea and it seemed like a workoutable case.
Okay. And then at some point were you aware at some point that a plea offer was made to Mr. Christopher, which he accepted, but then at some point the state withdrew that?
I wasn't directly involved, but yes, I was aware of that situation.
And then after that point in time, did Ms. Wood ask you to sit with her at the trial?
We pretty much always sit with each other if we're available, so yes.
Okay, so you're sitting with her at the trial didn't necessarily have to do with the fact that the plea offer fell through. It's just you were going to anyway, just because you're the more senior attorney in the courtroom?
Yeah, so there were multiple cases. I don't remember which ones they were, but there's always a kind of some shuffling around of what case is going to go. And so then if it was my case, she likely would have sat with me and vice versa.
Okay, so she only had one jury trial that she had conducted prior to this one. Is that right?
As far as I know.
Okay. So do you know, so you did review the discovery prior to trial, is that right?
Yes.
How did y'all divvy up the responsibility at trial? Did she say, I want you to take this witness and da-da-da?
Yeah, it was pretty collaborative.
But she was lead counsel at all relevant times, is that right?
I considered it her case. I did do some of the witnesses I recall in the charge conference and that sort of thing, but I don't know that she asked me to necessarily, as I just and more at that point was more comfortable doing it.
Okay, and I think you told me in just conversation that you were actively involved in the trial, is that right?
Yes.
Representing Mr. Christopher.
Yes.
And did you recall if you reviewed the request to charge that Ms. Wood submitted to the court and filed with the clerk? Did you review that prior to trial?
Yes.
Okay. And at some point in time, did Ms. Wood ask you to handle the charge conference?
I don't know if she asked me to, but I tend to do even as second chair, the charge conference in trials.
Okay. And if the record reflects that the judge asked you your opinion about whether certain charges should be given or not, or whether certain evidence should go out with the jury, you spoke up.
Yes.
Okay. So prior to trial, Ms. Wood had submitted a written request to charge on knowledge. You recall seeing that in her charges?
Yes.
Okay, so during the charge conference, Judge McBurney asked you about the knowledge charge. He says, well, I don't really think this applies because, this applies more like in drug cases, and I may be paraphrasing the judge, but he said kind of making some sort of analogy to like, constructive actual possession in drug cases. I don't really think this applies here. And then he asked you if you agreed, and the record shows that you said, okay, that's fine, we'll withdraw that. Do you recall that conversation? Okay, so prior to trial, did you know that knowledge is an essential element of hit and run?
I don't know that I thought of that specifically.
Okay. So did you review the statute on hit and run prior to trial?
Yes.
And were you aware of the case law that interprets hit and run as a offense? Had you reviewed the case law on hit and run?
I don't
to
recall.
determine? Okay. So at the time when the court asked you whether or not you wanted to withdraw knowledge, were you aware of the evidence that was introduced at the trial? Were you present during the whole trial?
Yes.
So you heard all the witnesses' testimony?
Yes.
You heard Kayla's newborn's testimony?
Yes.
And you heard that her cousin testify about how Kayla came up to her house and told her about what happened and things like that?
Yes.
Okay, so do you recall that do you recall Katie Newborn saying that Kayla told her that they thought they hit a deer that night?
I remember that, yes.
Okay, so was there a strategic reason that you withdrew the request to charge on knowledge?
No.
Was that, and I'm talking about at the time of trial, not now. I'm just talking at the time of trial. Was there a strategic reason for you to withdraw that charge?
No, there was not.
Okay. And regarding Kayla Newborn's testimony, you reviewed the discovery in the case, right?
Yes.
And so was there anything in the discovery where the state produced to you statements from Kayla saying that Mr. Christopher, threatened or tried to kill her before, or that he had told her where he had threatened to try to kill somebody else? Did you see any of that in the discovery?
The only thing I remember was her, I thought, making kind of outlandish allegations about him, something about killing somebody or something like that. And it, to me, seemed like she was trying to make him look bad without really anything to back it up. But I don't remember specifically what you're talking about, I don't think.
Okay, so I guess what I'm asking is, did the state file a timely notice to introduce 404B evidence expressly addressing these allegations, these outlandish allegations that Kayla testified about at trial, where she said he, threatened to kill her or threatened to kill somebody, had told her about where he killed or threatened to kill somebody else? There was no timely filed 404B notice from the state, right, on that subject matter?
I don't remember there being a motion filed or a hearing conducted.
Okay. And so when Kayla subsequently testified about those matters at trial, which was not in any of the discovery that the state provided to you prior to trial, was there a reason that you did not object to that testimony as improper character evidence or move for mistrial?
No, there was, in hindsight, I should have objected. There was no strategic reason not to.
Okay, well, I'm not asking you in hindsight. I'm asking you at the time of trial, was there a strategic reason for your failure to object to that testimony about these outlandish allegations about Landon Christopher telling her that he was going to threaten to kill her, or that he told her in the past that he had threatened to kill her or had, killed somebody else or something crazy like that? Was there any reason for your not objecting to that at the time of trial for a strategic reason?
No, there was not.
Okay. And was there a strategic reason for your not moving for a mistrial on that basis?
No, I should have moved for a mistrial.
And he had not, now regarding some of the body cam footage in the case, do you recall reviewing the body cam footage of the various officers?
I am not going to say that I reviewed every second of body cam before trial, but I do remember Ms. Wood showing me what she thought would be important.
Okay. So Ms. Wood was lead counsel, right?
Yes.
So if she had wanted to object to anything that you did, she could have done so, right?
Yes.
And now did you, and if you were responsible, or you had decided that you were going to take an active role in the charge conference, did you consider at the conclusion of the jury charge, objecting to the court's failure to charge accomplice corroboration at the time of trial?
Did we request it?
No, it was not requested.
So there was no strategic reason not to request that charge.
Okay. In your mind, based on your review of the evidence prior to trial with Kayla Newborn, an accomplice?
What does it mean, Ms. Feely, in your mind, to be an accomplice to hit and run? Because that's all that went to trial. The count 2 didn't go forward. So if the liability is on the driver, what's the, I'm just trying to think through what the evidence was in the trial that would have made you not look silly if you asked for accomplice liability, given what the crime of hit and run is.
So prior to trial, when the other count was in play, I think it would have been an appropriate strategic call to ask for it as to false report of a crime.
Agreed.
But I think it's pretty clear that the only duty is on the driver.
Okay. Now, I appreciate there's argument that maybe Ms. Newborn was the driver, but then we've got the wrong defendant. It's not that it's an accomplice situation.
That's my understanding.
Okay, so a strategic reason for not seeking accomplice liability or anything like that would be you didn't see that legally one could be an accomplice to hit and run unless there were 2 steering wheels in the car or something like that.
Right.
Okay.
So the defense at trial was that Miss Kayla Newborn was the driver, not him, right?
That there was reasonable doubt as to who the driver was, yes.
Okay. And Ms. Newborn was present in the car with Mr. Christopher based on her testimony, correct?
Yes.
And she did not stop and render aid to Mr. Duffy, right?
That's correct.
And is your understanding of the definition of accomplice someone who shares a common criminal intent?
I don't know the exact legal definition off the top of my head, but I would agree with that.
Okay. So it was a matter of whether or not the jury believed Kayla Newborn or not, right?
That was certainly a major part of it, yes.
And the trial court gave us a charge on the testimony of a single witness is sufficient to establish a fact, right?
Usually, yes. So
and that's what happened. That's what happened in this case, right?
Yes.
During the trial of the case, do you recall there was some testimony or cross-examination between you and the police officer about whether or not there was only one key to the Toyota Highlander or not?
Yes.
Was that something that was that a relevant point for you to make at some point?
I must have thought so at the time.
Okay. So did Ms. Wood ask you to review any of the discovery to determine whether or not there should be any pretrial motions filed in the case?
I don't recall us discussing I came into the case a little bit later.
Okay. And if I understand that Judge McBurney has, sort of written standing policies about timelines, deadlines for filing pretrial motions. If there is a need to request an extension, is that something that can be done in the case?
Yes.
Okay. And I believe you said that you tried cases under the old evidence code. Is that right?
Yes.
And are you familiar with the change in the jury pattern, jury instructions before the old evidence code and now the present pattern jury instructions? Are you aware of any differences in the change in some of the language of some of the common principles that are charged in every case?
I don't know the ins and outs of specific changes, but I do know that we use the current one and it does make reference sometimes to the older one, the older version.
Did you believe that there was ample evidence of Kayla Newborn's prior inconsistent statements in the case?
Yes.
Your Honor, if you just give me a minute, thank you.
Sure.
Also, just real briefly, was there a strategic reason that you didn't request a charge? And I believe this is a pattern charge and it speaks to immunity as well as leniency toward a witness. Are
No,
you familiar with,
I'm
was there,
familiar-
are you, yeah, was there a strategic reason to not request that charge,
No,
either in writing or orally at the charge conference?
there was no strategic reason, no.
Okay, and was there any strategic reason for failing to object to the court's failure to give that at the conclusion of the jury charge?
No.
Did you ever have a conversation with Mr. Christopher prior to trial or during the trial that he had a state and federal constitutional right to be present at all critical stages of his trial?
I don't remember a specific conversation about that. No.
Do you recall if the court ever mentioned that to Mr. Christopher in court?
I don't recall it being an issue.
Did you believe that there was some evidence to support a charge on impeaching a witness by showing the witness's capacity to perceive, recall, or relate the relevant event is impaired?
Did I think there was a reason to request that charge?
Yes.
I don't remember us discussing that, but I can't think of a strategic reason not to have requested it.
Okay, thank you.
Thank you as in you're done, or you have other questions?
Thank you, Edson. Thank you for your answer to your question.
Okay.
I know the court is has some time issues, so I'm just quickly reviewing my notes.
Okay.
So you said you don't recall reviewing every minute of the body cam footage. Is that correct?
Right. I may have, but I would imagine, given how the posture of the case kind of came up, we did think it was likely going to resolve. I probably did not watch every second of the body cam.
Okay. So if there was body cam footage that was played at the trial and the body cam footage contained evidence where an officer was telling Mr. Christopher that he didn't believe him and he was calling him an SOB and, didn't believe his story, was there a strategic reason to not object to that evidence
No, there was not.
or to move for mistrial?
No, there was not.
I don't have any further questions.
Ms. Eaglin, if you've got questions for Ms. Feely, and I'd ask you to truncate, if you don't mind, do you have a lot of experience? Because I find that Ms. Feely has lots of experience as a criminal defense attorney. I think that's clear in the record and from my personal experience. You may want to say something specific with hit and runs, but otherwise, if you go to the issues, please.
Yes, Your Honor.
Thank you.
In reference to your preparation for this case, you stated that you reviewed the applicable jury charges that was filed by co-counsel, correct?
Yes.
Let me ask you this. Did you review the current law at the time that was applicable when you went into the charge conference? Is that something that you had done?
Normally, and I think I did it in this case, I send both sets of requests to charge to our appellate attorneys and see if they have anything flagged. And I believe I did that in this case. So I reviewed them and I had someone else review them.
Okay. Is it customary for you when you are going into a charge conference to have taken time to review the applicable law?
Yes.
Okay. And you can say you did that in this case?
Yes.
Okay. You testified that you reviewed the current law and you did not believe that knowledge was an essential element of the crime, correct?
Correct.
Would that be your basis for having withdrawn that charge?
Yes.
Okay, so in reference to the defendant's right to be present, is that a right that you understand that a defendant is entitled to?
Yes.
And with that knowledge, is that a right that you would have sought to protect for your client?
Yes.
Okay, so it's fair to say that even if a conversation wasn't had with the defendant about it, that you did your best to ensure that that occurred, correct?
Yes.
Alrighty, there was some questioning of Miss Newborn on cross-examination about her prior testimony of being fearful of the defendant. Do you remember that?
Yes.
Okay, and in your line of questioning, after confirming that she was allegedly afraid of him, you then went on to pose different questions like, but then you went ahead and you text him. Do you remember that line of questioning?
Yes.
Okay. Can you explain to me what your strategy was in doing that?
You were hoping to show that she was, I guess, self-serving in her testimony and by saying that she was afraid of him and that was a motivator for her because she did lie. And so we already had that fact. And so we were trying to show her bias against Mr. Christopher.
Okay, and so is it fair to say that if you elicited testimony from her of being fearful of the defendant and even examples of being fearful of him, that that was a strategic reason of why you did that?
It was. I don't know that it was necessarily executed well, but it was thought out and purposeful.
Okay, in reference to the accomplice jury charge. Now we just talked about you having reviewed the applicable law at the time prior to going into a charge conference. You testified that you had no reason basically not to request the charge. Can you kind of explain to me why you did not request the charge? Is it because it's something that you didn't think was necessary at the time based on the evidence?
Which charge?
The accomplice charge?
There was no strategic reason. I just didn't think to request it based on the count that ended up making it to the jury.
Okay.
Is another way to put that is that you didn't think there was a reason to? I mean, the strategy would be why ask for a charge that doesn't fit the facts of the case anymore.
Right.
Okay.
Okay, the evidence that was put forth, do you recall if there was any evidence that Kayla Newborn was even aware that Mr. Duffy had been hit in this case?
I thought the information was they didn't know what they hit at the time.
Do you recall at what point Miss Newborn learned that Mr. Duffy had been hit? Had it been after they had left the scene?
I know from my recollection, there was some discussion, but I don't know that she knew that it was Mr. Duffy.
Okay.
And when we're saying Mr. Duffy, that a human was hit as opposed to a tree branch or a deer, no one knew, oh yeah, that's that guy Duffy. We got him with the side of the car.
That's my recollection.
Okay.
In reference to the immunity, excuse me, leniency charge that you were questioned about, do you feel like that was a charge that was necessary to request in this case?
I don't remember thinking to request it, so I don't think that was a strategic decision.
When you don't request a charge, is it because that you believe it's not warranted by the facts or the law? Can you explain to me why it is that you typically don't request a particular charge in a case?
I don't have a ton of experience requesting that particular charge, and it may just not have been something that I thought to ask for.
In hindsight, do you believe that it was?
Your Honor, I would object to that question. Hindsight is not relevant for purposes of this hearing.
Fair enough.
So although hindsight is not relevant,
It's not irrelevant to the analysis.
if she's claiming ineffective assistance of counsel, Your Honor, and she did not request a particular charge, I think it's relevant to know why.
Well,
Is it
and she
because she
said,
didn't think?
I agree, it is, and her answer was, it didn't come to mind, I may have overlooked it. And where you and Ms. Quo come in is, did it even apply? And maybe it didn't come to mind because it doesn't apply. If it does apply, then Ms. Quo will articulate the reasons why that was harmful to Mr. Christopher, that it wasn't given.
Okay, fair enough. Okay, can you tell me at the time that you tried this case, which this case was tried in 2021, at that time, what was your understanding of the applicable law? The evidence code is what I'm getting at, was applicable at this time.
So it had to have been 2022 that the case was tried, but I remember reading the code section that applied at the time, and so I think I was familiar with it.
Okay, and so would that have been the new evidence code or the old evidence code?
The new.
Okay, and you would have reviewed the new evidence code?
Yes.
Okay.
I'm sorry, I have a quick question. I don't mean to object, but what is the specific code section that you're asking her that she reviewed? I didn't get that part.
So there's the pre-2013 evidence code section that you questioned her about briefly. And so my question was more so a follow-up to that question of what code she believed to be applicable at the time.
Okay, I'm sorry. Thank you so much.
Okay, you were not lead counsel in this case, correct?
Right, it was Ms. Wood's case.
And as co-counsel, were you able to also make decisions on the case?
During trial, yes.
Okay, and if you made a decision that Ms. Woods ultimately did not agree with, who kind of trumped?
I don't know that we've had a ton of conflict on that. I think it's pretty collaborative. But if I was doing something that she disagreed with, certainly there would be a discussion and I would defer to her strategy.
Okay, and so if a particular charge was not requested, that was ultimately, is it your testimony here today that that would have been her decision?
In terms of the charge conference, I think that's a little different because I think I was kind of running that show, so that piece would have been my decision.
Okay, was she present during the charge conference or was it just you?
She was there.
Okay, but you were the more active role. Okay, do you recall if during that charge conference you were the one making all of the arguments, or did she ever chime in and also make arguments?
I think I pretty much did the charge conference.
Okay, and so is it fair to say that there was an understanding between you and her that that would be something that you handled and not so much her?
So at that point, I think we'd only had 2, maybe 3 other trials. And I typically, it's my practice to do the charge conference, whether I'm second chair or not.
Okay. And for the sake of time, Your Honor, I think that's all the questions that I have.
Got it. Ms. Quo?
Oh, just one more question. I'm
Yes,
so
ma'am.
sorry. Have you ever been found to have been rendered ineffective assistance of counsel?
No.
Okay.
Ms. Quo, any other questions for Ms. Feely?
Yes, so the defense theory was that, what was the defense theory?
That there was reasonable doubt as to who the driver was.
Okay, and so, um, the state had no evidence of the hit and run, who the driver, the state had no witnesses to the hit and run, is that correct?
Other than Miss Newborn.
Okay,
And
and,
Mr. Duffy.
well, Mr. Duffy didn't identify any driver, right?
No, but I mean, he was a witness to the hit and run. I'm walking and I get hit by a car, but no, you're right. He doesn't say, I know the driver was male or female or anyone like that.
So Mr. Duffy did not identify Mr. Christopher as the driver, is that correct?
Correct.
So you were aware of the evidence that Kayla was afraid that she would be prosecuted in this case.
I don't remember what pretrial discussions were had about that.
Well, if the evidence at trial showed that she was scared she would be prosecuted in the case, you would have no reason to disagree with that.
That's correct.
And do you recall that she thought that after Mr. Christopher turned herself in, she thought it was over with?
I remember there being some discussion about that. Yes.
And you previously testified that she had lied to the police officer from the get-go.
That was my understanding of how the report, her
And
statement.
and at the time of trial, she had not been arrested for any crime arising out of the circumstance, right?
Right.
And during the body cam footage, she corroborated Mr. Christopher's statement about what occurred that day, right?
That's my recollection, yes.
And she knew at the time of trial she could be prosecuted, correct?
I don't know what she knew, but it seems like that would be a fair inference.
Well, the record reflects that she said that she knew that she could still be prosecuted for this offense. You would have no reason to disagree with that, correct?
Correct.
And for whatever reason, at the time of trial, the state had not charged her with a crime arising out of this circumstance.
Correct.
And that would be evidence to support a charge on leniency granted to a witness, correct? I'm sorry, I didn't hear you.
Yes.
And there was no strategic reason for your failing to request that charge, correct?
Correct.
Now, there's a jury question for the jury based on the defense in your case as to whether or not Kayla was the driver or whether Mr. Christopher was the driver, right?
Yes.
And so when the court charged the jury on when the court charged the jury on single witness, he essentially told the jury that the testimony of Kayla was sufficient to establish a fact, right?
Yes.
And she was the only one who could inculpate him, right?
Yes, directly.
And based on your defense, you're contending she was the driver. She should not be believed. The jury should believe that she is the driver because she made all these she lied to the police and she made a lot of inconsistent statements at trial.
Correct.
Do you recall she testified at trial that she actually called her cousin the night of the incident and told her what happened?
I remember the cousin being involved, yes.
Okay. And do you remember that the cousin actually testified that, no, Kayla didn't call me to tell me specifically what happened. What she said was, I want to come up there and talk to you about it. She didn't feel comfortable talking on the phone about it. Do you recall that?
Yes.
So her credibility as a witness was pivotal to the state's case, right?
Yes.
And so for that reason, and based on your defense that Mr. Christopher was not the driver, and that in fact it was Ms. Kayla Newburn that was the driver, was that evidence to support a charge on accomplice corroboration to count one hit and run?
I'll
At
tell
the
you
time-
right now, I don't, Ms. Feely can answer it however she wants, but it's not. I mean, you can't be an accomplice to hit and run. You were either the driver or not the driver. Maybe the immunity charge should have been given, and I'll certainly consider that. But I don't want you to invest more time in this.
Sure.
Should have charged on accomplice.
Yeah, I understand. I just believe it was a jury question. I have no further questions.
Ms. Eaglin, anything else?
Just a really quick question. Do you recall, you all questioning Kayla in detail about whether or not the state had promised her anything in exchange for her testimony?
I believe I did her cross and I don't recall crossing her very much, if at all, on that.
If the record reflects that the defense questioned Kayla about whether or not she was if the state had offered her anything for her testimony, would you have any reason to dispute that that is not what happened?
No.
Okay. Do you recall there being any evidence showing that Kayla could have even been the driver in this case?
I think we were just hoping to show that there was reasonable doubt about who the driver was. We didn't have any direct evidence.
Let me ask a better question. Was there any evidence of a deal that had existed between the state and Kayla?
Not that I was aware of.
Okay, and so in light of the evidence, is it fair to say that you did not request a leniency charge because the evidence didn't warrant it?
Your Honor, I think that's been asked and answered. Object.
Well, you retilled the ground, so I'm just letting Ms. Eaglin close the loop.
I didn't have a strategic reason for not requesting the charge based on the evidence.
No further questions from the state, Your Honor.
All right. Ms. Feely, you may step down. Do you have any other witnesses, Ms. Quo?
Well, Your Honor, are you closing for the day? Are we wrapping up the hearing or are we continuing it to another day? For
Well,
argument?
I asked the first question, so you answer my question, then I'll answer yours.
Okay. I don't believe that I will be recalling Ms. Wood.
Okay. Do you have any, so you don't have any additional evidence? I know there's argument. I'm gonna get to that point in just a moment, but do you have any other evidence you want to present?
No, we would rest.
All right. Ms. Eaglin, were there any witnesses you were going to call?
No from the state, Your Honor.
All right. So the evidentiary piece of the hearing is closed. We are going to pause for the day because I have a homework assignment for the two sides. I think that there is an issue concerning my failure to charge the jury on knowledge, not knowledge writ large. I know why I push back on the generic knowledge charge, but I'm going to give you both two citations. I'd like you to look at them, and you don't need to file a brief. You can shoot me and you, meaning the other attorney, an email with your thoughts on how I ought to navigate these two cases. The first is Mondor, M-O-N-D-O-R, 306 Georgia 338. And the second is Harrington, spelled as it sounds, 364 Georgia Appeals 186. I guess that's not fair because hair could be spelled. It's H-E-R-R, Harrington. Harrington, like the fish, Harrington. But you've got the site, 364 Georgia Appeal 186. Both of those say to me that the charge that I gave on hit and run was deficient. And Ms. Quo, you will likely argue fatally deficient, and I don't know that I disagree, but I want to give Ms. Eaglin a chance to think about it too. You did file a response and identified correctly that Ms. Quo didn't say a whole lot about what was the problem with no knowledge charge, but it has prompted me to do a little research while you all were examining the lawyers. And I'm concerned about it, and I don't want us to invest in any of the other argument about other grounds, because if that was a mistake I made, the other stuff really doesn't matter. So I'm going to give you each a week, because again, I'm not looking for a 20-page brief or anything like that. Look at those two cases and then give me your thoughts about how the charge that I gave And I'll email you so you don't have to find it. The hit and run charge is on my screen right now, but the K word is nowhere in there, nothing about knowledge. And I don't know that that meets the Supreme Court and the Court of Appeals test. So give me your thoughts on that. If I am convinced that that was a serious enough mistake, we don't really need to push these other things, and I'll enter an order. And then if you want to appeal it, you can appeal it. If I think based on Ms. Eaglin's reassurances that it wasn't a big mistake, then we will have part 2 of the hearing, which will be argument. We will certainly get Mr. Christopher patched in. That can be virtual for everyone. You're welcome to come to court, but it will be argument on any other issues you want to touch upon. But for me, if this knowledge concept was wrongly omitted, the other errors, even if they were errors, don't matter because the jury didn't have an essential element to consider, or I didn't instruct them on an essential element of the crime of hit and run, which was the only crime that remained in the indictment that Mr. Christopher faced. Any questions about that direction? Ms. Kuo?
Your Honor, I appreciate that. I did just want to quickly cite the case of Johnson versus State 360 Georgia App 63.
Yeah, I read that, and that is not as on point for you as these 2 cases. You should be much more excited about Harrington and Mondor. I read Johnson. That's the case you cited.
Yes, I just wanted to say that was the case I cited.
Yep, I got it. I read that one because it somehow it wasn't linked to Mondor, but I think it talks about knowledge, but it has to do with the quantum of proof of knowledge, actual knowledge, or just sufficient evidence that the driver knew or should have known. But in the Johnson case, the jury was instructed that the state still had some burden to prove knowledge. And I don't know that in this case, the judge instructed the jury that there was a burden on the state to prove knowledge that this accident occurred. So look at those 2 cases. And like I said, you can find other cases that distinguish Harrington or Mondor or are more on point to our facts. But it's a pretty small universe when it's assessing the knowledge element of the hit and run statute. Ms. Eaglin, any questions?
No questions.
Okay. I'll send you all an email with the charge that I gave. You'll see it in the transcript as well, but I just pulled it out of the final charge, and we'll work from there. Let me check with the third person I need to hear from. Hey, Mr. Christopher, do you have any questions about what we've been discussing?
Not at this time. I just want to know if I'll be able to speak with Ms. Kuo when this concludes.
Yes, could you put us in a breakout room if possible? I don't know if that's possible.
It's possible, and I'll do that, and then I'll ask my friends from the Department of Corrections when that conversation is done between Ms. Kuo and Mr. Christopher, you are free to drop off the call. I won't close out the breakout room. I'll just leave it open for the screen that says Wheeler CF and for Ms. Kuo. You guys talk as long as you need to. When it's done, Ms. Kuo, you're free to drop off, and folks at Wheeler, you're free to drop off as well. Thank you for making Mr. Christopher available.
Your Honor, can someone just notify Ms. Wood that she is free to go?
Yep, she's in fact not free to go. She needs to stay in my courtroom to do some
I'm
stuff.
sorry. That's
That's
what
all
I meant.
Yep.
Sorry, my bad. I'm
No bads at all. But I appreciate you releasing her.
okay. Thank you so much.
You bet. Let me add Wheeler and Francis Kuo, and that'll be that for this record. Thank you. Mr. Morris, I would like to quickly call the plea and arraignment calendar, and then we'll take your client's plea, assuming it's still a plea, if that works for you.
It is, and we'll be at the court's convenience.
Great, thank you. Let's pivot then. You're welcome to gradually pack up or stay for plea and arraignment, whatever you want to do, but thank you for your help on this. She didn't put her email here. we've got a plea and arraignment calendar. It turns out a bunch of folks filed waivers. So I'm gonna call the case, each of those, just in case there's a lawyer or a client here, but they don't need to be. And I want to make sure that the prosecutors know there was a waiver. Position 1 is Jamel Miller. Hi, Ms. Willingham. I know you're here for that. Ms. Nelson tells me waiver filed, they were excused, so we'll get a scheduling order in place.
Yes, and I've been in touch with Ms. Kim.
Great. And is that Ms. Collins? You don't need.
No, it's Attorney Judy Kim.
Judy Kim. Okay, got it. Judy Kim. All right. Eduardo Torres Acock. Same situation. He's a co-defendant in the case, but he's represented by Ms. Grofsky, who I think used to work in your office. And she filed a waiver. So Ms. Nix, you should be getting discovery to Ms. Grofsky. Co-defendant is Rashad Green. Mr. Green is here, and I think your lawyer is online. There she is. Let's do this. Let's remove that spotlight and spotlight Ms. Roberts. There she is. Hey, Ms. Roberts, how you doing today?
I'm doing good, Your Honor. How are you?
I'm well. Mr. Green, why don't you come up to the podium just so you can see your lawyer and she'll be able to see you. Ms. Roberts, is Mr. Green going to be waiving arraignment, or does he want to be formally arraigned?
I'm going to do the waiver arraignment, but I need to get some contact information, some good contact information for him, if I can do that, and then we'll waive arraignment.
You bet. We'll do that in just a second. So, Mr. Green, Ms. Roberts is your attorney, and she's going to waive arraignment for you, which simply means she's just entering a plea of not guilty. That'll trigger the prosecutor, that's Ms. Nix behind you, her obligation to get to Ms. Roberts' discovery in the case, which will be police reports. I don't know if there's body cam, should be some crime lab reports based on what these charges are. She'll get all that to your lawyer, and then you and Ms. Roberts will be able to talk about that. I'm going to ask you to write down on a piece of paper, if one of those, any piece of paper you can give Deputy Gordon, a good phone number and email address, and I'm going to get that to Ms. Roberts so she can track you down, because she needs to be able to connect with you. And Ms. Roberts, do you have one of our waiver forms, or should Ms. Nelson email you one?
If she can email me one, I'd appreciate it, Your Honor.
All right, we'll have her send you a waiver, and if you'll fill that out and e-file that, then we'll get a scheduling order out, okay?
All right, thank you, Your Honor, so much.
Great, and if you don't mind staying on, I'm just going to get the card from Mr. Green and make sure I can read it, so that I'll be able to share with you that information. And if it's real simple, I'll probably just send you a chat right through, just to you, through Zoom.
Perfect.
And that waiver has been emailed to you.
All right.
All right, it ends in 5900. Good phone number. And then I think I can read all that. Okay, great. Do you need anything else from Mr. Green, Ms. Roberts?
No, I will give him a call today. I'll give him a call later today.
Okay. Ms. Nix, anything you need to share with Ms. Roberts or Mr. Green about the case at this point?
No, sir.
Great. Ms. Roberts, sit tight, and I will, let me figure out how to get to just you. There you are. All right, I'm going to send you the phone number and email address, and Mr. Green, you're free to go. Thank you. You too. All right, you should have the phone number and the email address. Did you get those?
I do have them, Your Honor. Thank you so much.
Great, thank you. You're free to go. Waive and schedule. Position 4 is the other co-defendant in that case, Mr. Daniel, Kenyon Daniel, right there. And who is representing Mr. Daniel?
I don't have an attorney or lawyer right now.
Okay. Are you planning on hiring one, or do you think you qualify for appointed representation?
I plan on hiring one, Your Honor.
Okay. When is that going to happen?
As soon as I'm able to be financially stable to go ahead and do it. Right now, I'm running into an issue financially.
Okay. I trust you're working on it. I need to make sure we're advancing your case, though. Is that something that you think you'll take care of in a few weeks, or you think in a few months?
Like frankly, right now it'd be like months or maybe 2 or 3 months after that.
So then what I'm going to do is have you speak with either Ms. Wood or Ms. Feely about appointed representation. That's not a permanent status. You will get a great lawyer that way. If you then find that you have the financial resources to hire someone, that person can replace your appointed counsel. But I don't want to have your part of this case, stuck because we're waiting for you to hire someone, whereas your two co-defendants are moving forward. They've announced they've entered their pleas of not guilty and the case is moving forward. And I'd like you to keep up with them. So when I'm done calling this calendar, I'll ask, will it be Ms. Wood or Ms. Feely?
It actually looks like Ms. Cabrera de Amor filed an entry on March 5th.
Oh, you got a lawyer.
I'm on. Is this Mr. Daniel, Judge?
Oh, there she is. This is Kenyon Daniel. How are you, ma'am?
Okay. I'm well. I'm sorry. We had a concern. I'm on federal call with Judge Leffridge. So I had to respond to some things that seem to be happening in the room as we speak. But I do have him. I did file an entry. I filed consolidated motions. I would just need contact information for him, unless, of course, he was hiring private counsel.
So he may end up doing that, but he is not in a position to do so right now. And he may, after working with you, decide that he's in a great situation. So let me check. I'm pulling up the docket now. All right. Yeah, it has your motions. For whatever reason, it doesn't reflect your entry of appearance. It's listed there. I'm going to have Ms. Nelson send you our standard waiver of arraignment. If you'll file that, that ought to trigger getting your name in the record as counsel of record. And Mr. Daniel, I'm going to have you provide a phone number and email, and I'll get that to Ms. Cabrera so she can contact you and talk about your case. You can let her know your plans. And you can speak much more candidly with her. Anything you say to her is spoken in confidence. It'll be privileged about your financial situation. And you and she may decide, hey, you know what? She's representing you and you want to stick with that. Or it may be that she provides you with legal representation for a couple months and then you bring on board attorney X. Ms. Cabrera, are you able to stay on long enough for me to put in the chat the email and phone number, or what's your situation?
Yes, I can. I'm sitting outside of the jail. Your Honor, you have a tomorrow, and I have some people I need to see. So I'm just sitting outside of the jail before my 1:30 calendar to run in, talk to them. I can wait a couple seconds.
Okay. 3074 and 7137. Got it. Is there one that's better than the other?
3074 is my personal, and the next one is my wife's.
Okay, but I'll give her both just so she can track you down. Okay, and that's 163? No, it's 63 because that is the L, the last letter of your name. 63. All right.
Yeah, the email.
Yeah, 63. All right, I'm going to share that with Ms. Cabrera. She will reach out to you. You guys can talk. And Ms. Cabrera, if you will get that waiver in, we will move the case forward.
Okay, thank you, Judge.
All right, and if you'll stay on until you get.
I have my chat open.
Great, I'm about to send it. And you, sir, are free to go.
Thank you.
You bet. Hold on, before you go, let me make sure we've got a good address in the system for you. I know I said you could go. Brent Court.
572.
That's it. We're good. You'll get stuff in the mail from court. You'll get calls and emails from your lawyer, but if it's from the court, it'll go to that address.
I also have an alternative address?
Sure, but talk to your lawyer about how to do that. She can, I don't know about alternative, we mail things to one address. So you'll just need to pick which one you want, and then your lawyer can help you with a change of address form.
Okay,
All right?
thank you, Your Honor.
Sure.
I got it, Judge.
All right, hold on, email coming to.
Okay.
There you go.
All right. Thank you so much.
All right, take care. Position
All right.
5.
Thank you, Judge. Have a good one.
All right, bye-bye.
Mhm.
Position 5 is Jean or Jean Isaac.
Subject to notice, the state will request a bench warrant.
All right, we'll look into that. How about Terry Cummings? Right there. Hey, Mr. Cummings. I'm all right. This lists Ms. Hanson. Is this Ms. Hanson when she was your colleague or in her new iteration?
Judge, he will be mine. I'm gonna waive arraignment today. I do need to speak with him though to get good contact information,
Okay,
and I'll get that waiver filed today.
great. And Ms. Willingham, this is your case?
Yes, Your Honor.
All right, so Mr. Cummings, you should stick around. Ms. Wood's going to want to talk to you to better introduce herself, get contact information for you. She's your lawyer. Ms. Willingham, whose voice you just heard, is the prosecutor. Ms. Wood is telling me that she's going to enter a plea of not guilty for you. She'll get the discovery from the prosecutor, and you and Ms. Wood will talk about what's next with your case. Any questions for me? Okay. Ms. Willingham, is the alleged victim in this case the same as whoever the victim was in whatever prior family violence battery happened to make this one a felony? If that question makes sense?
It does make sense, Judge, and I did look, but I don't recall. I can pull it back up though.
It's not, I'm just curious if you knew off the top of your head. All right. Mr. Cummings, my guess is you have a bond that says you have to have no contact with someone. Is that correct? Are you abiding by that condition? Great. Okay, keep doing that. Ms. Wood, anything else?
No, Your Honor, thank you.
All right, thank you. So Mr. Cummings, if you'll take a seat, Ms. Wood, once I get through this calendar, she's gonna come talk to you. Myandris Swinney? And I apologize if I mispronounce your first name. Meandris. Is it Swinney?
Yes.
Great. Ms. Swinney is here and Ms. Feely represents you.
I filed a waiver on Friday, but I do need to speak to this guy.
All right. So Ms. Swinney, Ms. Feely's already waived your arraignment for you, but she does need to talk to you just to get contact info, okay? Ms. Nix, your case?
Yes, sir.
Great. So you'll get discovery to Ms. Feely and we'll move this along. Ms. Feely, anything else on behalf of Ms. Swinney?
Not at this time, Your Honor.
All right. Erica Ragland.
Sydney Gibson here for Ms. Ragland. Ms. Ragland is here, so that's going to be a waiver of arraignment, and we'll enter a plea of not guilty today.
All right, you were listed as the lawyer for Mr. Daniel. I don't know if at one point you ever represented him or if we just had a typo.
I think he was at one point in my office. I had his case pre-indictment, but it is no longer mine.
Nope, clearly, it's Ms. Cabrera. All right, so you represent Ms. Ragland. You're going to waive arraignment. You've already done the waiver or you will do one?
I have not. I will do a waiver and file it today.
Great, well, I think we've got them right there. So if you fill it out and leave it with Deputy Gordon, I'll make sure it gets filed.
And Judge, I know the calendar says it's mixed, but that's gonna be my case.
I got that, yep. I wrote, Ms. Nelson shared with me that this is your case and you'll get discovery to Ms. Gibson.
Yes.
Great. All right. Ms. Ragland, do you have any stay away conditions in your bond? You do? Okay, you understand them? They're not presenting any issues right now? Okay, if they do, let Ms. Gibson know. I don't know if there's a child you're trying to spend time with, but you can't, but if something needs to be modified, make sure you talk with Ms. Gibson before you decide to modify it. Okay, all right. So Ms. Gibson, once you get that waiver filled out and get it to Deputy Gordon, you and your client are free to go.
Thank you, Judge.
Thank you. Valeria Quarterman shouldn't be here. She waived. The lawyer is a Rachel Saint-Fleur. So I think she's filed an entry, but Ms. Nelson was aware that that's the attorney for, she forwarded me the waiver for Ms. Quarterman. Right?
Judge, that concludes my business. May I be excused?
Yes, ma'am. See you this afternoon. Position 10 is Rina Johnson. It's not that old a case, kind of, sort of. No contact from the DA's office? Okay. Ms. Nix, bench warrant?
Yes, sir. Statements for bench warrant.
Okay. And finally, Sean Deloach. Ms. Kennebrew is from your office?
Yes, and I have not had contact with Mr. Deloach, but I see that it was dismissed at the prelim, which I think sometimes causes.
Oh, yeah, that does create confusion sometimes.
So if the court would allow me to see if I can find contact information, I will reach out to them.
Yeah, let me check one thing. Okay, it's not that long ago though that it was dismissed, so I'll do a bench warrant, but this is one where Mr. Deloach can always walk in. But here we are. Okay. Is there anyone here for a case that I haven't called other than Mr. Morris's case? All right, someone will talk with Ms. Sweeney and we will pivot now to Mr. Morris's case. Let me get that. And is it pronounced Reidenbaugh? Great, you guys can come to the point. Are you able to stand?
I'm walking now, thank you.
Okay, then let's have you all come to the stand. Ms. Clark, this is your case?
Yes, Your Honor.
Great, good morning, thank you for being here, or good afternoon. Yes, sir.
I have a laptop with videos and photographs on it. And plug in later. I would prefer to describe them. If the prosecutor has a problem with my description, then I can show them the order. If the court wants to see them, I'll show them. Otherwise,
They're available. You let me know they're available. You're gonna go with a description, and if we need more, we can get there.
Thank you.
Sure.
I can't make an offers because
Ms. Rivers, are you ready for a plea?
calls right now. But that sounds like so. I don't know if you guys-
Excellent.
it's like a-
All right. This is 23 SC 189-536. Get it up on my screen.
I don't think that I'm gonna agree to this anyways. So, with the information I have now, but, so let's just do it. Thank you.
All right, 2 counts of unlawful eavesdropping or surveillance. Ms. Clark, are you ready?
Yes, Your Honor.
Great. Mr. Reidenbaugh, the way this is going to work is that in just a moment, Ms. Clark will put you under oath. Once you're under oath, you'll need to answer all her questions and mine truthfully and completely. If at any point during the process you have questions of your own because something confuses you, surprises you, isn't going the way you thought it was going to go, let Mr. Morris or me know, and we'll do our best to answer them. Will you do that? Great. When you're ready, Ms. Clark.
Thank you, Your Honor. Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury? You can put your hand down. Please state and spell your correct legal name.
My name is Scott, SCOTT.
I'm sorry, I'm not gonna
Oh, yeah, you know, can you tap that microphone, not down at the bottom where there's that red light? If you'll put your finger on it for a second, there you go, it's green. And if you two would switch positions. Thank you. All right. Spell your last name again.
It's Reidenbaugh, REIDENBAUGH.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
I have ADD medication and Xanax, which is kind of anti-anxiety.
What was the first one?
ADD medication.
Do you take those medications daily?
Yes, sir. The ADD I do, the anxiety is just as needed.
Okay. Did you take any of those medications this morning?
I did, yes, Your Honor.
And when you take those medications, do they make it easier for you to understand what's going on, or do they make things cloudy, hazy, fuzzy?
No, it just helps me to relax and not be as anxious, I guess.
Okay,
Yeah.
but they don't interfere with your ability to process the events around you.
No, Your Honor.
How old are you?
I'm 43.
What's the highest level of education or the last grade you completed?
Bachelor's degree in college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Count 1, unlawful eavesdropping or surveillance, and count 2, unlawful eavesdropping or surveillance.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
And have you had an opportunity to review your waiver of rights with your attorney?
Yes, ma'am.
And did you understand your waiver of rights as explained to you by your attorney?
Yes, ma'am.
Is it your decision to waive your rights today?
Yes, ma'am.
Have you had enough time to speak with your attorney about the charges in the indictment against you, including the facts and circumstances relating to these charges?
I have, yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Morris, do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any defects in the indictment for purposes of this plea?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
The state will provide those. The minimum is 1 year in prison. The max is 5 years in prison on each count. And that sentence can be either probated or suspended, depending on the court's discretion. Do you understand that your plea today is called a non-negotiated plea and that the state may recommend a sentence to the court, even if it's one that you do not agree to?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
You understand that if you enter a non-negotiated plea, you do not have the right to withdraw your plea once the court enters its sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
You seem confused by that.
I guess it was my bond from jail. I guess
Okay.
I didn't know it.
That's neither probation nor parole.
Okay. Didn't know, ma'am.
Do you understand that if you're, that if your sentence, at the end of this today includes probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Your Honor, it's the state's understanding that the defendant wishes to seek first offender, so I'll do this part of the colloquy at this time. Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pled guilty or no contest to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked?
Yes, ma'am.
You understand that this means that you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in the indictment against you?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As
being entered under Alfred versus North Carolina, Your Honor, for the record.
Okay.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment number 23, SC 189013, how do you plead to count one, unlawful eavesdropping or surveillance?
Guilty under Alfred. Guilty under Alfred.
How do you plead to count two, unlawful eavesdropping or surveillance?
Guilty under Alfred.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes, ma'am.
At this time, Your Honor, the state will provide a factual basis for the felony plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on August 8th, August 30th, 2021, a report was filed at the Roswell Police Department documenting unlawful surveillance that occurred on May 8th of 2020 and 9/26/2020 at the incident location of 1025 Devereaux Chase, Roswell, Georgia, Fulton County, 375 is the zip code. Chantra Redenbaugh advised that Scott Redenbaugh had filmed sexual intercourse encounters with her at their home without her knowledge and consent. The victim, Ms. Redenbaugh, said that on 5/8/2020, the defendant had set up a GoPro camera in a guest bedroom, unbeknownst to her, baited her into the room and filmed the sexual encounter. The victim said that on 9/26/2020, the defendant filmed another sexual encounter with her using an iPhone that he dropped during the encounter and denied having recorded the encounter. The victim said that she and the defendant were having some marital problems and that she had discovered the video recordings on the family MacBook computer on October 28, 2020, and filed for divorce on 10/29/2020. Victim said that the divorce attorney advised her not to file a report until after the divorce was finalized. The divorce was finalized on August 20th of 2021, and she filed the report on 8/30/2021. Officers from Roswell Police Department were assigned to the case and interviewed the victim on 10/22/2021 and was provided with the copies of the two videos that the victim had found on the family computer. Officers reviewed the videos and could see that on 9/26/2020, the video, the defendant and the victim were having a sexual encounter. The victim was seen laying face down, knees bent and pulled in toward her stomach with her face resting on her hands and arms, naked and near the edge of the bed. The defendant can be seen, I'm gonna skip over some of this, can be seen.
Is it safe to say as a summary that that video, the 9/26 video, depicted a sexual act?
Yes, Your Honor.
Okay.
That was unbeknownst to the victim that she was being filmed. Your Honor, the state is requesting,
You didn't,
Oh, sorry.
I don't need you to go into detail, but the May 8th video, when the police reviewed it, they reached the same conclusion, that it was a video of a sexual encounter between, at that time, husband and wife, but according to then Ms. Riedenbaugh, that also was recorded without her knowledge or consent.
Yes, Your Honor.
Okay.
Your Honor, the state is asking in this case, and I will explain the legal basis for the request. We're asking for 4 years on each count, the counts to run consecutive. We are also asking that there be special conditions.
8 years total of prison, of probation?
Of probation.
Okay.
We are asking based off of, I know that that this case goes back to May of 2020, Your Honor. However, the defendant, after he was arrested, there were several instances where, while the defendant has been on bond, the victim has, shared those encounters, but they can be seen as deliberate attempts to intimidate the witness. And for that reason, we're asking for certain parameters. It's our understanding that the defendant has some psychological issues as well, but we are asking for a psychosexual evaluation to be completed within 30 days of the final disposition of this case, and that he complete the treatment if recommended. Defendant provides a HIPAA waiver to the state limited only to the verification of his treatment. If defendant is prescribed any medication for his mental health by a physician, he will remain compliant with all medication, no drugs unless prescribed. Defendant is prohibited from disclosing or publishing to third parties, websites or other entities, videos, pictures, drawings, or recreated images of the victim. The defendant is prohibited from committing any further acts of unlawful eavesdropping. The defendant shall have no violent contact, including abusive or harassing language with the victim and the victim's 3 children. When the victim's 3 children visit the defendant is prohibited from recording, photographing, recreating, or drawing any images of the children unless the victim is aware of this ahead of time. The defendant is prohibited from publishing any photographs, videos, or images of the victim's 3 children without the victim's express consent. And when the victim's 3 children visit or stay overnight with the defendant, the 3 children will have unrestricted access to their personal communication devices to contact the victim. And the victim shall have unrestricted access to communicate with her 3 children. And while the defendant is on probation, he is prohibited from traveling out of state with the children unless there is a agreement ahead of time. Your Honor, the reason the state is asking for these additional special conditions is because there's documented where the defendant has called the victim fat girl, emailing her. She also, even though it was the intent of the victim to try to keep the this entire encounter with the arrest secret from her children, the defendant told the 3 children that he was arrested and it was because of the mother. He told them that the victim is a horrible person and that she lies. They have a special needs daughter that is 11. He's told that child, "Fuck you," to her face. There was an instance where the defendant called and wanted to speak with one of the children on FaceTime. The child was getting out of the shower and was giving resistance. He shouted the defendant had shouted that he's seen it before, come to the phone. When he picks the children up for the visits, even though that is a part of their parenting plan, he takes their communication devices from them, has even left them in the mailbox at the victim's home. There are a lot of things that the defendant has been reported to have done. Again, I just want to make sure that I have. The state believes that the different things that he's done has been in ways to intimidate the victim in order to get her to either dismiss the charges. Involving the children is a very serious thing, but he's told the children, "I'm your father. I should be giving you medicine. Your mother is just being mean." He's also recorded the children by video as well as on recording, trying to ask them questions to try to find some facts or things that the mother may have done. And Your Honor, it's just a situation. This is a difficult situation, of course, but it's very concerning that even though the defendant has been out on bond, in this case since November, that he has done a series of different things to intimidate the victim in this case, and then furthermore to involve the children. As indicated, there's a special needs child, and these are the reasons that we're asking for the provisions that we've asked for.
Okay, thank you. Good afternoon, Ms. Jackson. How are you? It may be that you're away from your computer. I'll try Ms. Tucson. Hello, Ms. Tucson.
I'm sorry, Judge, I'm here, but I'm having problems turning my camera on. Can you hear me, Your Honor?
Yes, ma'am. And we'll work through that. I appreciate you being on. I just wanted to confirm, Mr. Reidenbaugh is seeking first offender status. What criminal history information do you have on him, if any?
Yes, Your Honor. He does not have any prior arrests on file. Nothing in addition.
Great. Thank you so much. Our afternoon calendar is not going to start till 1:30, so I will see you or hear you around 1:30.
Thank you.
Thank you. I forgot to ask, Ms. Clark, if you have shared an important amount of detail from the victim's perspective and victim as well as victim as mother. Anything more? Was there a victim impact statement beyond what you shared?
Yes, Your Honor, that's what I was saying. Please pardon me. The victim is here and she does have a statement that she would like.
Okay, I didn't mean to skip that at all. I apologize. I just, I heard a whole bunch. And I want to say this, I will hear from you with whatever you want to say. I need you to listen to me for a sec. But this is not the family division. I am not the judge who presided over the divorce. I am not going to modify. I cannot modify any conditions that were part of the divorce in terms of visitation, child support, et cetera. I know this isn't about the money, but it's clearly about relationships and broken relationships and damaged relationships. So I just want to let you know the limitations of my authority, and that is to determine if there's a basis for a plea. I think there is. Mr. Reidenbach is pleading guilty. But some of these conditions that Ms. Clark is asking me to oppose are bordering, they're not quite there, on potentially getting into the field that's not mine, which would be you get the kids on Wednesdays and you get them on Fridays. And I know that's not what Ms. Clark said, but I just want to share that with you before you share with me, whatever you want to do. If you'd come on up and stand near Deputy Gordon, that would be great. That'll work. Let me do this. That way court reporter can see you and hear you. Ready for you.
Okay, thank you, Your Honor. My name is Chantra Reidenbach. I'm 42 years old. I have a family deeply rooted in the justice system, so I have a profound respect for this entire process. So thank you for letting me speak. I fell in love with Scott back when I was 20 years old, right when I met him, quite frankly. He was my everything for 19 years, and I loved him so much. The day I discovered that he was filming me during intimate moments between a husband and a wife, my whole heart was shattered. After all we already been through with job losses and mental health issues, I stood by his side, and I thought he stood by mine. But it seems that instead of being the loving husband and father I thought I had married, he's actually a predator. To be treated with such disrespect, only to serve his sexual fantasies and deviations, made me feel like a piece of trash and sent me into a deep depression, so much so that I cried myself to sleep for 8 weeks straight, until he was forced to move out of our home due to his volatile and threatening behavior by his own attorney, divorce attorney. Some of the things he said to me after I found the videos include, "Nobody will want you. You're fat, have 3 cats and 3 kids. Good luck moving on. You're gonna die. I will take you for all that you're worth. I'll get at least $500,000 out of this. And my least favorite, you're a fat cunt." While enduring this heartbreak, I had to continue to provide for my family and care for our 3 children, one of which is special needs, with no help from Scott. He continues to harass me, and his anger towards me has also been transferred to our children as he weaponizes them to punish me. He took everything from me. I lost all trust in men, looked at myself as disgusting, and felt like a piece of garbage that he tossed in the trash, used, abused, and discarded. The beautiful vision I had of marriage and a happy family is forever ruined because of Scott, as I will never trust anyone with my body or my heart again. I have been in therapy since this happened and have taken some significant financial hits, $100,000 in total to pay for therapy, and a very expensive divorce, which Scott deliberately dragged out as another form of punishment. I believe all of this punishment is enough, so why he continues to try to punish me is disturbing, to say the least. Leading up to finding the videos, Scott's behavior was very concerning. He had isolated himself in our guest bedroom, was making no money, but told me he had a job, so that was interesting. 100% commission job. I continue to support the family, take the girls to their doctor's appointments, daily activities, and hold down a very demanding, high-profile career. I have a background in IT, forensics and audit specifically, so his behavior was very suspicious. So I did some analysis on phone records. I had asked for the computer, but he then subsequently hid it from me for a week and then brought it back out and said everything was fine. So I did some IT audit and analysis trickery and found that on the day I'd asked for the laptop, October 18th, to be specific, 2020, he had run something called a disk drill, which is to wipe all files, but he missed a few. So these 2 videos that I did find are just the tip of the iceberg, if you ask me. He had also transferred the videos from his iPhone to a laptop. And why would you do that? Because you're editing them and posting them somewhere. But I was unable to find the trail. I also spent $10,000 in forensic analysis of the Mac. It's a special skill set. Apparently Windows is easier to analyze. And they weren't able to find anything other than what I found. So all that to say, the minute I found the videos, well, the day after I filed for divorce, that we were done at that point. And I had no choice. So I've never consented to him filming me during these intimate moments that I found. The only time he cried through the divorce process was when he got caught with these videos. And then he asked me what I knew, and I didn't tell him, but he mentioned 4 other instances I was unaware of. Seattle, Athens, and another area of vacationing that we had been to, and I was not aware. I have suffered severe anxiety since the discovery of these videos, feel disgraced, disrespected, violated, humiliated, and extremely concerned about who he shared these videos with and across what internet platforms and mediums, because there are so many nowadays. Let's see, yep. As a corporate executive for a global organization who's 100% responsible for providing for her family, I can't run the risk of these violating acts being publicly available, let alone let my daughters ever see or find out about their father's actions. The thought of the possibility continues to haunt me. I will likely never know the extent of his sexual deviations, but in addition to the anxiety, hurt, distress he has caused me directly, even more devastating is the hurt.
Need you to slow down a little bit
Oh,
for the court reporter.
Sorry. I'll start over, sorry. Not all the way over. The thought of the possibility continues to haunt me. I likely will never know the extent of his sexual deviations, but in addition to the anxiety, hurt, and distress he has caused me directly, even more devastating is the hurt and pain he has caused our 3 precious girls. Shortly after he was advised to move out of our home in 2020, he left the state of Georgia, stayed with his family in Ohio. He did not tell my girls when he was coming home and did not tell them the truth as to why he was leaving. He left me to tell the girls about the divorce by myself, care for the pets and kids by myself, pay for all 3 girls and home expenses by myself, and even had to put our elderly dog down, Willie, by myself. I was all by myself, and he didn't have a care in the world about me or our girls. 3 months later, he returned and his paranoia escalated. For example, he came into my home to get the girls and saw I had a new set of Nest cameras and proceeded to unplug every single one that he could see. He fled the house, my house, to Ohio just a few days thereafter and left the girls in tears. After I pressed charges and he was arrested in November 2020, he disappeared again for 2 months. And upon his return, he told the girls, "Mommy put me in jail." They were 2.5, 6, and 8 at the time. These are just a few examples of Scott fleeing because of his paranoia for his illegal acts he has committed. It's been a common escalating theme prior to the divorce and after. He's forbidden my girls any personal form of communication with me, which is documented in the divorce decree through the family law that he needs to let them use smartwatches. He takes those away. While under his care, he searches their belongings at length before they're able to get in this car. Ms. Clark touched on some of these, so I'll keep going. My girls have continued to be collateral damage as he marches them to the front line in order to save face and maintain a sense of control and ultimately not accept responsibility for his actions. Scott took these private videos knowing I'd want to fly out the door, knowing I didn't approve, knowing it would hurt me, and knowing that it would violate and embarrass me. He did not care and still doesn't care, which is evidenced by his continued harassment of me. For example, calling me FG, fat girl, asking me why I still have a Peloton and a stand-up desk, yet I'm still ... He was also ordered by the judge during our divorce to attend 6 months of consecutive counseling with the children, all of which he ignored, intending at best 2 therapy sessions with my girls. It's been very confusing for my girls. To be told things about the one and only person they can undoubtedly rely on for safety, security, emotional, and financial stability. These precious children seek validation from their own father, but they're not getting it. It is truly evil to put these thoughts in their innocent minds and not to attend counseling they so desperately needed after he abandoned them not once, but twice. My hope is that this doesn't happen to anyone else, and I also hope that Scott gets the help that he needs, so maybe one day he can show our girls how a man should treat a woman and how a father should treat his children. Through the heartbreak, I remain grateful for 3 things. My Carly, 11, Reese, 9, and Annalise, 6. Their happiness and healing are more important than mine. and his. Thank you for your time, Your Honor.
Thank you for sharing that. It sounds like this has been a difficult few years. All right, Mr. Morris, talk to me first about why this is an offered plea, and then anything else you want to share about the situation.
Yes, Your Honor. This is an Alford plea primarily because it is our fear, a reasonable fear, that an admission of guilt is inappropriate, and if made, would be used by Mrs. Riedenbaugh to try and change the conditions of custody and visitation in family court, which is frankly where it belongs. The fact of a felony conviction would be used by her as a cudgel. And in all honesty, Judge, there are some questions of fact that remain as to the alleged victim's knowledge of some of these events. And for that reason, I discussed with my client his options and advised him that under the circumstances, a reasonable way to resolve this case would be a plea under Alford. It would have been a no low, but we can't do that without the state's consent. So because of certain beliefs about what the truth is and because of what the effect of a straight guilty plea would be, we're offering under Alford.
Okay, I follow that. Thank you.
Thank you. I would like to put into context the two events. And what we're dealing with is two events. As the court was just told by Mrs. Riedenbaugh, Scott and Chantra were together for 20 years, 12 of those married, raising 3 children together. This is not some stranger he is having intimate contact with. This is his wife at the time. Their relationship during this 20 years, anyone would describe as sexually active. Many would describe as kinky. Over the years, there have been mutually agreed upon, consented to, naked photos and videos of Chantra made by Scott on multiple occasions. It is clear from at least one video that I have seen and numerous photographs, including photographs that were made on the day of count 2, that Mrs. Riedenbaugh is posing for the camera. Scott has his iPhone camera, and she's posing in various positions that expose various parts of her body, including intimate parts. It can't have been, I didn't know it was happening, because she's facing the camera.
Are these images that you've shared with Ms. Clark?
These are
or at least described
to Clark gave to me in discovery.
Got it.
And that we have, and that were found on the laptop, which I'll get to in a second.
Okay.
Yes, they're not a surprise. Now, these 2 that are in question, I believe the evidence would be, had there been a trial, that Mr. and Mrs. Riedenbaugh, while still married, Mrs. Riedenbaugh was living in the master bedroom. Mr. Riedenbaugh was living in the guest room downstairs. And on this particular evening, both had been drinking alcohol, not to excess, but were in a good mood. And she came downstairs to his bedroom. And on May 8th, 2020, which I believe is count 1, he had set up a GoPro video camera on the night table. The lights are turned out, and the police report reflects where Detective White reviewed the video in its entirety, and he said, quote, "No images of the encounter are captured." It's dark, it's black. Now, you can tell they are engaged in intimate conduct, and you can tell that he set up the camera. It just doesn't show them. Once they get in bed, the lights are out. You can't really see anything. You can only hear what is clearly Mrs. Riedenbaugh enjoying what is occurring. But she says she didn't know the GoPro was on. On the 26th, the circumstances are different. They are in bed together and they are having a sexual encounter, and it is clearly consensual, and both are clearly enjoying it. Mr. Riedenbach takes a series of photographs, some of them with her facing him, some of them when she is not facing him. At one point in time, it switches from a photo to a video, which if you've ever operated a cell phone trying to take a photo or a video, their buttons are right next to each other and it can change. At any rate, a video is created. Mrs. Riedenbach says she didn't know it was going to be a video. She obviously knew it was going to be photographs, but she posed for them. Okay. These two things occurred on May 8th, 2020 and November 26th, 2020.
You said November, the date we've got is September?
September.
Okay, and I press only because if it's a whole nother incident, I just wanted to know you were describing something that wasn't charged.
It is
Okay.
the same date, Judge. My apologies.
Okay.
That video, if you watched it, it would be about 1 minute in length. I think 1 minute, 2 seconds. The following 2 weeks later, on October 6th, 2020, Mr. and Mrs. Riedenbach went to Seattle from Atlanta to celebrate his birthday and have a trip in Seattle. They had a lovely time. They did engage in intimate contact. There was no video. There are no photographs of that. On October 18, 2020, let me take a step back. Everything that was on Mr. Riedenbach's cell phone camera had been uploaded to a laptop, which was kept in the house. Not where the kids could get it in a special. And there was an independent hard drive attached to it too. On October 18th, 2020, Mr. Riedenbach deleted all of these photographs and all of these videos from the hard drive. He attempted to delete them from the laptop, but apparently there is a catch somewhere in there that he missed. But he made an effort to delete them. On October 28th, Mrs. Riedenbach, who has extensive experience in IT and knows how to get into things and laptops, found a way to recover what had been permanently deleted. And she found the catch that somehow had not been deleted. And she found the photographs and the videos. She did not go to the police. She did not stop or attempt to stop him from interacting with the children. She sent him a text message that said she was offended to the extreme. And she had found the minimally consensual photographs and videos. Now, only she can tell you what minimally consensual means. I take it to mean some of them she had certainly agreed to, some of them she may not have known.
But that term minimally consensual is not of your invention. That's what she communicated to.
Have it as an exhibit on my laptop if Your Honor would like to see it. I don't think anybody disagrees.
No, I just wanted to know.
M-I-N, consensual, M-I-N, which I took to be minimal.
Okay.
At any rate, she discovers this and confronts him with it on October 28th, 2020. On 11/1, she texts him about minimally consensual. I found him, I'm offended, this is terrible. And 3 days later, she files for divorce. She makes no allegation about videos. She makes no allegations about any threats. She makes no allegations about any improper conduct with her children. That is 5 days after she's found the videos and 3 days after she's told him she's offended to the core. So the divorce is filed on 11/4/20. On 8/16/21, there is a settlement agreement signed. By the way, I have a copy of the divorce petition for Your Honor and for the state if they would like it, and a copy of the settlement agreement for Your Honor and the state if you'd like to look at it. But I'm telling you, there is nothing in the settlement agreement signed by both parties in August of 2021 about photographs, concerns for the children, concerns for her welfare, anything he may have done, any mental conditions, any problems, anything, nothing in there in the settlement agreement. The next day, on August 17th, 2021, the consent permanent parenting plan is signed by both parties. I have a copy of it for the court if you need it. There is nothing in the consent plan talking about improper videos, photographs of her, problems with him dealing with his daughters, photographs of his daughters not being able to communicate with her. Nothing is in that consent permanent parenting plan, and she is given primary custody, and he has wonderful visitation and has enjoyed exercising that visitation. On 8/20/21, the divorce decree is signed by Judge Schwab, final decree. 10 days later, almost a year after discovering these videos that hurt her to the core, she went to the Roswell police and filed a report. Investigator White from the Roswell police visited with her, viewed the 2 videos, and conducted an investigation. On November 4, 2021, he got an arrest warrant from Mr. Riedenbaugh. Mr. Riedenbaugh was arrested without incident. No problems whatsoever, was released on bond 3 days later. Of import, Detective White, based on concerns stated by Mrs. Riedenbaugh, had each of the 3 daughters separately forensically interviewed by professionals, videotaped and witnessed by him, to determine had they ever witnessed any threat from Mr. Riedenbaugh, against Mrs. Riedenbaugh, against them, any inappropriate behavior, any wrongful conduct whatsoever. The detective wrote in his supplemental report, forensic interviews of daughters, no threats, no improper conduct, and they loved their father. I'm sorry, love the father is not in the report, it's in the video of the children. In addition to that, because there was a concern expressed by Mrs. Riedenbaugh that the detective contacted, I don't know what this stands for, RIAU. I assume that's a police, I think it's a police agency that checks internets and missing children and pornography and the like. He sent photos of Mr. Riedenbaugh, Mrs. Riedenbaugh, and both of them to RIAU to be run through facial recognition for any evidence on the internet of either's presence. None was found. Because Chantra was concerned that Scott had sold their sex videos on the internet, they investigated that. Quote, there does not appear to be any videos of Chantra and or Scott available for sale on the internet anywhere. That was the conclusion of the experts who searched it at the detective's request. The laptop that Mrs. Riedenbaugh found the catch in was sent for forensic analysis. Yes, she paid for part of that cost, and so did Scott. He paid for it too. Nothing untoward other than the photos of Chantra and the videos was found on the laptop. Nothing regarding the daughters, no pornography, no inappropriate visits to any particular websites, and absolutely no evidence of distribution or publication of anything that was on that laptop. To put a fine point on it, the September 26, 2020 video that comes after the still photos where she's facing the camera existed a total of 22 days. It was made on September 26th. It was deleted on October 18th. 22 days was the entire time that it existed. I would point out to the court one other fact that Mrs. Riedenbaugh did not share with the detectives, but I think is relevant in the context, Your Honor. When Mrs. Riedenbaugh went to the police to complain about the illegal eavesdropping, she did not tell the police that she had placed a voice-activated recorder under the bed of Mr. Riedenbaugh in his bedroom downstairs in the guest room where he was living. She placed it there without his knowledge, without his consent, so she could listen to what he had said to whomever, not just the girls if they were down there, but anybody. And she did it for days and for weeks. And she recorded his private conversations in the privacy of his bedroom without his knowledge. When Scott found the device, actually, he didn't find it. One of his daughters found it and said, "Dad, what's this?" He confronted Mrs. Reed, and she admitted it. She'd gotten caught. And we have that on an audio tape, if there's any question about it. He did not go to the police. He did not tell the police, even though it was a violation of the same criminal statute that he had violated and is standing here today. Bottom line, Judge, he's 42 years old. He has no criminal record of any kind, no history whatsoever of inappropriately touching his wife or his children or anybody. He's a graduate of the University of Georgia. He's worked in IT. He is presently working 2 part-time jobs to pay child support, to help pay the medical bills that are not covered by insurance for a special needs daughter, to help pay for the private school tuition for his special needs daughter. And he works 2 jobs, a construction management solutions, inspecting commercial property that's being financed. And at night, when he doesn't have the children, he works in the receiving department at Lowe's. And he does that because he loves his 3 daughters, Carly, Reese, and Annalise, who are 11, 9, and 6. They love their father. There has never been a single complaint since the day of his arrest from his divorce lawyer, from her divorce lawyer to his divorce lawyer, even though there has been correspondence with complaints. And I have the correspondence. Her lawyer says, well, he didn't pay for this medical bill on time. His lawyer says she didn't tell him ahead of time she was going to incur the expense, blah, blah, blah. Correspondence between divorce lawyers since the time of his arrest. None of the complaints that we have heard today about anything to do with the children or anything to do with her. There were conditions placed on Mr. Riedenbaugh when he was arrested that did not permit him to contact at all his wife or family. When Lauren McCauley was the assistant district attorney handling this pre-indictment, she was kind enough to agree with me to make a change so he could exercise his visitation. Unfortunately, although he could exercise his visitation, he could not be in the same place that his wife was in. That was a condition. Did he tell his girls that their mother had him arrested? Yes, because they wanted to know, why aren't you coming to ballet? Why can't you come to the house? He said, hey, the mother had me arrested. I can't do it. I have conditions. Now, Mrs. McCauley and I, along with Chandra, figured out a way to use, what's it called, Wizard? It's an email system.
Our Family Wizard.
What is it?
Our Family Wizard.
Our Family Wizard, that allowed them to communicate without violating any order. And in those communications, Mrs. Riedenbaugh says, and I've got a copy of it, I'm not worried about the restraining order. I mean, when it comes to Carly and the kids, they're too important. You don't have to worry about that. I'm not worried about that. So she doesn't sound scared. And then for Halloween, there's an email where he came to the house where technically he shouldn't have been because she was there. And she said, "Thank you for coming. The girls really enjoyed it. You know, maybe we ought to try and do this more often," or words to that effect. Again, I have a copy of it. I can't speak to whether he's called their names. I don't know. I don't want to get into that. But I do want the court to know that the conditions that are requested are just absolutely uncalled for and unnecessary. There are some that we don't have any objection to. As a matter of fact, I have a letter from Mr. Riedenbaugh's psychiatrist judge who says, well, let me take a step back. He regularly sees his psychiatrist and he regularly sees a psychologist. Psychiatrist issued a letter on February 27, 24, that he's been seeing Scott since May 6, 2019. General anxiety disorder and ADHD. Lists the medications he's prescribed for him. I see him every 3 months and last saw him in my office February 23rd, 2024, less than a month ago. He's doing well. I do not believe he has any sexual deviance or any diagnosis of a paraphilia. I have much experience working with sex offenders over the years. He does not demonstrate the symptoms or fit the profile. I do not believe a psychosexual evaluation will reveal anything or is indicated. I have a copy of that for the court and for the prosecutor should you want it. With regard to taking photographs of his own children, it's just not reasonable, Judge, to stop a father from taking pictures of his girls on their birthday or on visits at the beach, ballet recitals, Christmas. There's no history of any inappropriate photos or recordings of the girls or anybody else other than Mrs. Riedenbach. The publishing photos of kids restriction, there's no reason he can't put proud pictures of his kids on Facebook. There's no reason he can't send them to their grandparents. Grandparents live in Ohio. They're both in ill health. They do not travel very often at all. Those kids have not seen their grandparents in 2.5 years because the bond conditions won't allow it. There is no reason for Mrs. Riedenbach to have the right to access to communicate with her children when they are doing their parenting time with their father. It's not in the consent plan. The consent permanent parenting plan allows him that exclusive time with them. There have been no complaints from the divorce lawyer in written correspondence regarding this topic that mama couldn't talk to the kids. And the proper forum for that, as Your Honor has mentioned before, is family court. Now, no objection to a special condition that says the girls should be allowed to call their mother if they want to. I mean, that's not a problem. But to require them to have access, for her to have access at all times, is just uncalled for. With regard to travel out of the state, there's absolutely no basis for that restriction. Again, that's appropriate for family court. He has not been able to take the girls on a meaningful vacation while his bond conditions have existed. As I mentioned, his parents live in Ohio. It would be wonderful to take the girls on a trip to see them. And nothing in the consent permanent parenting plan speaks to that, even though Mrs. Riedenbach knew of the photographs in the video at the time she consented to the plan. Mr. Riedenbach has been on bond with these conditions for 2.5 years, Judge, without a violation having been raised. If there was a deliberate attempt to intimidate the victim, I'm unaware of it. There's no record of it. I would say to the court that in all fairness, this court should sentence the defendant consistent with the facts and the context, I would ask that Your Honor accept his plea under offered, that Your Honor impose 3 years probation on count 1, 3 years probation on count 2 to run concurrent, the standard conditions of probation, and that Your Honor impose the sentence under the First Offender Act.
As with all things, it's important to hear both sides of a scenario. And I'm not saying that there are two sides to the story. This isn't a story. It's a family that imploded. It's a tragedy, but clearly there are different perspectives on these things. Mr. Reidenbaugh, you have a right to be heard in the very same way that Ms. Reidenbaugh did. And so if there's anything you want to add, you are free to. You talk to me, though, even though you may be saying things you want other people to hear. You and I keep eye contact, but you don't have to say anything at all. Your lawyer was very thorough, as he always is, but he is your spokesperson. He's not the real deal, as in Mr. Reidenbaugh, real deal in a different way. So if you want to share anything with me, I'm listening.
Yes, Your Honor, thank you. I just wanted to say that I am truly sorry. And I never intended any harm. In the 20 years that we were a couple, the 12 years we were a married couple, these are all personal and private pictures or videos that was between us. And I would never intend any of those, any harm, or even did I, or nor did I, will I ever disseminate any videos, pictures of us anywhere to anyone. And with that, I'm just want to say I'm truly sorry to the court and to Chandra.
It's the latter that's more important. You don't have to apologize to me. I don't really know you. And this case is a great example of why I'm happy not to be in the family division, because those poor judges deal with just some real complicated personal emotions are involved. And so people may not be thinking straight, and words are spoken that are so hurtful, and you can't unwind them, and the collateral on the kids, and it's human existence, it's human nature, and it is the bread and butter of the family division, of which I am not a part. Ms. Clark, anything that you want to add? This is not a rebuttal time. I believe that these two realities coexist. And having worked with Mr. Morris before, he's not someone who, in a McCarthy-esque way, says, I've got a document that shows this. I suspect that in that folder is all the things he said. I don't need to see any of it, because none of it makes this easier for Ms. Reidenbaugh, but it certainly puts some of it in a helpful context for me as I process all this. In particular, the Alford part, that's to me what I wanted to best understand, because I believe Mr. Reidenbaugh is trying to take responsibility for this, but when someone is doing that, Alford isn't always consistent with it, but I better understand now his perspective on it. So having said all that, was there anything that you wanted to add?
Your Honor, just wanted to add, I have a copy of the parenting plan, and defense counsel has said that there should be no interruptions, but it does clearly say that the children shall be allowed to contact either parent at any time they choose on their devices. Children should be able to, if there's a missed call from a non-custodial parent, then there should be reasonable efforts to ensure the children return the call. There has been evidence that there has been reports by the victim that devices have been left at the home before the children. Also, Your Honor, just wanted I've had conversations with defense counsel, and there are a lot of documents that he has referenced. And even just last week, I had indicated to him that if there was any mitigation or if there was any reciprocal discovery, all of the documents that he has alluded to, none of those have been provided to the state.
Got it.
That, and then also I just want to bring out this point. there was a reference to being kinky and sex and stuff like that. But Your Honor, these two incidents, the victim has reported that she did not consent, was not aware of the fact that she was being filmed. And that is the crux of the charge. And regardless of whether they were married or not, any attempt to minimize that is really doesn't really appear to be appropriate. The state also objects to and had no knowledge that the defendant was going to be seeking an Alford plea because it seems to me that there has been an attempt to not accept responsibility. And I think that the Alford plea does that. Regardless of the, I've talked extensively with defense counsel about the different issues as far as the interactions with the children, the comments, and I did share those things with him. And, you know, to have him to stand there and to say that there's been no instance of that. And because of the request of Ms. Riedenbaugh, the state did not file a motion to revoke bond, but it is very concerning that a defendant that is on bond for these charges would make the different comments and involve the children regardless. So those reports by the victim should be taken into to strong consideration. And regardless of whatever pictures that were taken or whatever was provided, in these instances, the victim did not consent, which is against the law.
All right, thank you.
May I correct one thing?
One thing, we don't need a big back and forth. I hesitated even to ask Ms. Clark if she had any other thoughts, but your presentation was lengthier than what we usually have on the defense side, which is fine. It fits this situation. And Ms. Clark might have truncated hers a bit because she thought this was going to be a plea where there's not as much back and forth. So yes, one thing.
With the greatest of respect to Mrs. Clark, during the negotiations to try and reach a negotiated plea, I informed her that our plea would be entered under Alford versus North Carolina in an email. And she responded, I object to that. We're not going to have a negotiated plea. So
okay,
it was not a surprise.
Okay, got it. Appreciate that. So, Mr. Reidenbach, first, I am accepting your plea. Oh, I need to talk to you about first offender very briefly. Ms. Clark covered it, but the judge has to interact with the defendant as well. First offender is something for which you qualify. It means that by pleading guilty, even under Alford, when you leave here today, you don't have a conviction. You will be on probation. You'll be on probation as a first offender, but it's not a conviction. So if you are looking for a job or to go back to school or whatever, and there's that box, check this box if you're a convicted felon, you should not check it because you're not a convicted felon. But you're going to be under sentence. You're going to have a probation officer. That probation officer is going to know you're on first offender status, but otherwise you're treated exactly as someone who pled guilty to a felony. There's no special dispensation. The real benefit, other than that you don't check the felony box, is that if you successfully complete your probation, when it's done, this can be removed from your record. You earn that by complying with probation and doing what you need to do. But it is something that is afforded to anyone who has your criminal history, which is no criminal history. And I think it's appropriate in this case. I did not hear Ms. Reidenbaugh say, I want to destroy Mr. Reidenbaugh. I think she would like you to be physically and mentally healthy, and maybe not interacting with her in some of the ways she feels like you've been interacting with her. And those are reasonable and thoughtful requests. And it's consistent sentencing you as a first offender. The risk you need to understand is that if you violate your probation, and there are two main ways you do that, you get arrested for something else, or one of these special conditions that I'm going to impose that in my limited way, and I say limited because I'm not the divorce judge, in my limited way, trying to keep the peace, if you violate one of those, and that comes to me and the state can prove it, and it's a much lower burden of proof. It's not beyond a reasonable doubt. It's by a preponderance. If they can prove that, I can revoke your probation, re-sentence you as a felon up to 10 years in prison, because that would be the maximum 5 + 5. I don't tell you those numbers to spook you. You have to do something really dumb and dangerous and harmful to others for me to say, oh, now it's 10 years in prison. But it wouldn't take much if you've deceived all of us and you are engaging in anything remotely similar to this, you're arrested again, or it's brought to my attention, whether you're arrested or not. Ms. Reidenbaugh finds online your website you're hosting, and there are images of her on there that aren't things that anyone would want publicly shared, something like that, and the walls come tumbling down. And I would resentence you. You would be a felon. You'd go to prison for a while, and you'd be alive, you get out of it, but a hope of having a meaningful career would be over. So I just want to make sure you understand the risk. For lots of folks, it's a very manageable risk, but you know that best of all. Do you feel like you understand the benefit of first offender and the risk of first offender?
Yes, I do. Thank you, Your Honor.
Understanding those, do you wish to be sentenced as a first offender?
Yes, I do, Your Honor.
Okay. Well, I find there's a factual basis for your plea. I think that part of your acceptance of responsibility, and I appreciate Ms. Clark observing that this is a little bit of a weave and a dodge of a plea, because I think the facts are complicated. But you have a right to put your former family through a trial. You could do that to clear your name. And Ms. Reidenbaugh would have to testify, and 12 people would have to look at some of those pictures. And you would be within your right to do that because you believe in your heart of hearts that this was all consensual. And if it was consensual, it's not a crime. But you've decided to accept responsibility to the extent that there's not a trial. And it may seem to Ms. Reidenbaugh or her family, this is more along the lines of a slap on the wrist and just don't do this again. And it's not, because you're carrying some serious risk with a probation sentence as a first offender. But I think more importantly, not only to Ms. Reidenbaugh, but to the kids, there's no trial. And this isn't gone. People don't forget about it, but it stays within the four walls of this courtroom. And more importantly, you and Ms. Reidenbaugh and the kids and family members, and not whatever happens in a trial. So I think that is an important thing to acknowledge. That being said, I do find there's a factual basis, and that your plea was knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but you have decided after consulting with your lawyer and maybe your divorce lawyer as well, that it's in your best interest to go forward with an offered plea. Is that correct?
Yes, Your Honor.
Knowing means you've understood everything we talked about. Any questions about anything anyone has said so far?
No, Your Honor.
All right, I accept your plea. As I've said, I am sentencing you as a first offender. I am accepting this under, it's actually North Carolina versus Alford. Same case, people call it Alford. I'm accepting your plea under that case, and I understand why. You are offering your plea pursuant to that U.S. Supreme Court case. I'm sentencing you pursuant to the Probation Options Management Act. What that means is that while you're on probation, if you have a minor violation, not of a special condition, I'm going to tell you what those are, but let's say you're supposed to meet with your probation officer every Tuesday, first Tuesday of the month, and you miss one meeting. That's a bad choice. And probation may want to deal with you on that, but you don't have to come see me. They may say, hey, you have to do 10 hours of community service, and you'll have a little hearing with them. And if you agree with that, you'll sign a piece of paper saying, I don't need to talk to the judge about this. I missed my meeting. I'll do 10 hours community service. But if it's a big deal, as in you violate a special condition or you get arrested, that comes back to me. All right. On count one, I am sentencing you to 3 years. On count two, I am sentencing you to 3 years. They are running consecutive to each other. Count one is 3 years of probation. Count two is 3 years suspended. But you will be under sentence for all 6 years. And these conditions that I am about to share apply to your sentence as it is a suspended sentence as well. So you're not going to have a probation officer looking in your ear to see what's going on. But if 4 years from now, that would be by the time your sentence is a suspended sentence, you violate any of these conditions, Ms. Reidenbaugh brings that to the state's attention. they can file a petition to reinstate your suspended sentence. And I can, and it'll be just like a probation revocation. It just won't involve probation. The state will need to prove up the violation. And if I find they have, then I can reinstate your suspended sentence as probated or as prison time. So you've got 6 years during which you need to comply with the conditions that I'm going to share. Number one is that you not violate the law. So you get arrested, jaywalking, DUI, murder, any of those things, you're going to come back to me as well as dealing with wherever your arrest takes you. Number two, you need to take any and all medications that medical professionals prescribe you. Number three, you may not disclose in any way to anyone any image in whatever format you have, still, video, whatever, of your wife, clothed, unclothed, anything like that. If it comes to light to the state or to Ms. Reidenbaugh that you have posted, shared, Instagrammed, it doesn't matter the technology. If you disclose in any way any image of Ms. Reidenbaugh, that's a violation of your probation, unless she has consented to it. She can always say, hey, you know what? You took a picture. There was a event. I was there. The kids were there. And it was a particularly cute picture. You got the kids, you got me, and you want to share that. She needs to say, that's okay. But I want to be clear. It's a photo of her, not of the kids. If she is in a picture and you want to share that with anyone, you better have her consent or don't share it. No violent contact with Ms. Reidenbaugh. And I'm including that would be a violation of the law anyway, but you should know that the conditions of your bond are gone as of today. And unless there's something in the divorce settlement, there's no reason why you can't call her or write her, provided you're doing it in a civil manner, to arrange to spend time with your kids or to talk about whatever the two of you are going to talk about. And if there are issues with that, that's really not a Judge McBurney thing. It would be Judge Schwall's successor dealing with that and the divorce attorneys and the way you and she are interacting or handling your ability to spend time with the kids. I'm just looking over the list of the other ones. I am not going to impose a condition about you traveling with the kids. That's 100% out of my lane. That's something that is in the settlement agreement and the parenting agreement. And if it's not, those lawyers and that judge will deal with that. So I think that is the extent of the conditions I'm comfortable imposing that don't encroach on the terms of any divorce decrees, parenting situation, et cetera, or the authority of the judge who sits over that. There's a separate set of lawyers who can go back and forth about anything along those lines. I'll tell you, I was intrigued by Ms. Clark's request that you be required to leave your kids' electronics with them at all times. But I got kids and I like it when they don't have their electronic devices because they actually look at me when I talk to them. And so I would never deny a parent the ability to say, hey, you know what? For a couple of hours, no screens. We're just going to go outside or we're going to do that. We may watch television, but you're not going to watch television while you're doing something like that. That being said, it sounds like it is part of either the settlement agreement, the parenting situation, that your 3 daughters need to be able to contact their mom and she needs to be able to contact them. If Ms. Reidenbaugh thinks that's not working, criminal court is not the right space. It's family court. And so you need to make sure you are making them available to talk to mom. And if mom is trying to talk to them through you, through their own devices, you're not actively thwarting that. But I am making it clear it is not a violation of your sentence if you decided, hey, kids, no screens for a little while. We're going to draw, we're going to do something else, but we're not going to do TikTok or YouTube or whatever it is they do. It's a healthy thing to do. Don't use that as some kind of sword and shield with Ms. Reidenbaugh. If she is trying to reach the kids, make sure you make it happen. But that might be through you to them. And as I said, if that's not working to the extent she wants it to work, the way to fix that is through divorce lawyer and divorce lawyer, not criminal defense attorney and prosecutor. I want to draw that line pretty clearly. This case can't be used as leverage in that case, and that case isn't used as leverage here. What I would like to see, and I know I'll see it if I don't see you again, is for this to move forward in as healthy, and I use that word loosely because it's not a healthy situation right now, and safe way as possible. These three little girls now have a broken household. It's probably not going to come back together. There may be two separate complete households for them in the future, but there's always mom and there's always dad, and you're half of that equation. And you need to invest in making that as healthy as possible for those three little girls. And whatever ill will you may have for Ms. Reidenbaugh because she brought charges against you, you don't take that out on them. You don't use them as a way to show Ms. Reidenbaugh a lesson. And I trust she will refrain from doing the same. You owe that to the little girls, if not to your ex-spouse. So those are the conditions that I'm going to impose. Ms. Clark, anything more you think that I wrote down every condition you recommended. So I didn't forget, oh, wait a minute, publishing pictures of the kids, that isn't my space. And the psychosexual evaluation, Mr. Reidenbaugh is under adequate care right now. I believe that I don't need to get into that space. We can always revisit conditions of probation if we need to. Anything more you want me to consider?
Would you consider, just because that the no violent contact include, no abusive or harassing language, like name calling and stuff like that?
So what I'll say is this: no violent or abusive contact. I don't want to hang meanings on those words. And, parents yell at each other sometimes, and divorced parents yell at each other sometimes more often than undivorced parents. You're an adult, and you're going to need to use the discretion you think you should use in interacting with Ms. Reidenbaugh. I don't want to elevate to it's a violation of probation every disagreement you guys have. But I heard very clearly some lacerating language that you are alleged to have used with Ms. Reidenbaugh. I advise you not to use that anymore. That might get us back together again. But otherwise, that's grown-ups need to sort things out themselves. Mr. Morris, anything else on behalf of your client?
Nothing, Your Honor. Thank you.
We're not done. Ms. Toussaint, can you hear us now? This is the
yes, Judge. Can you hear me okay?
Yes, we can hear you. Ms. Toussaint is with probation. She will not be your probation officer, but she's going to give you some reporting instructions because she's going to either tell you someone's going to contact you or give you a window in which you need to report, and you don't want to miss that because you'll start off with a probation violation. Ms. Toussaint, what do you want to share with Mr. Reidenbaugh?
Mr. Reidenbaugh, what city do you live in?
Roswell, ma'am.
Okay, so that is still Fulton. All right, may I have a phone number and address for you?
Well, before you do that, you don't mind if that's on the record, Mr. Morris? I don't know if the spouses have non-public.
Okay.
Okay, all right.
Or it can be emailed to me if that works better. All the contact information can be emailed to me if you prefer that.
That's up to you.
I like email, that's fine.
We'll email Ms. Toussaint if you'll give us your.
I'll get you her email.
Thank you.
Okay, so Mr. Morris, counsel for Mr. Reidenbaugh, will email you the address and phone number. What are the reporting instructions?
I'm going to double check. Our reporting instructions have revised once again because of construction. Usually we give you a date to report in, or an officer will come out to your house to verify your residence, okay? But just so make sure that is a verifiable address so you won't get a warrant for a non-report, okay?
Yes.
And I will send
you
the
I'm sorry.
via email. And if the attorney could include your email as well, that would be great.
Yes, ma'am.
All right, so it's phone, address, and email.
Yes.
All right, I will give that to Mr. Morris. Anything else, Ms. Toussaint?
No, that's it. Thank you.
Okay, thank you. All right. I was going to say, let's not start up our next calendar till 1:30, but look what time it is. I need to give Ms. Rivers a break. So we will start our 1 o'clock calendar is 1:45 okay, Ms. Rivers?
Yes, it is.
Okay. Then we will be on break until 1:45. And Mr. Morris, there is something written on the back. I know that, but we're repurposing this card. So ignore the stuff in black. You want the stuff in blue. And that's Ms. Toussaint's email address. Ms. Reidenbaugh, I wish you the best of luck as you move forward. I appreciate you being here. I often only get one half of the case, and it is an eloquent presentation by a defense attorney, and the prosecutor is left reading kind of a dry police report. Ms. Clark is usually more animated than a dry police report, but it was very helpful to hear from you directly. I know it wasn't easy to talk about this. I am hopeful that we've partially closed the door on a chapter, and you and your daughters are able to move forward, but stay in touch with Ms. Clark if things come up, okay? All right. And I'm gonna ask you all to leave first, and then Mr. Reidenbach can leave. You don't have to leave if you don't want to, but then I need to let them go. All right, thank you.
Approach on,
Yes.
on another matter.
Yes.
Thank you.
And you're welcome to take a seat back. You've been standing a whole lot. Oh my gosh, I'm honored. Why not here? Strange set of facts for your last.
No, but I don't
Somebody's
know.
charger, yes.
Yeah.
Laptop.
Let's see if it's fine.
Yeah.
Our partners.
Maybe. Yeah, she was sitting right
Bring
here.
me out of retirement.
He could. I mean, he could dangle enough money. You'd come out.
Thank you.
Hey, you're
We'll
welcome.
figure out whose it is.
All right.
It's my last court appearance. I might be happy to help out his team get ready for it.
Yeah. He stays busy. He keeps Art Leach and others fully employed.
And 50 years. in the schools.
Wow. You've earned it. Congrats. You guys still have the spot in Marietta?
Yes, some version of
I
that.
thought you'd lived
Oh, no, we're in Sandy Springs.
on the square. Okay, that's what I was thinking.
It's a
Sandy
little bit
Springs.
longer than
That's
I
what it
thought,
is.
so
Wrong
we're
town.
like
Yeah,
kind of
never.
behind schedule.
Okay, good.
Still in,
Still
No, we've
Yeah.
gradually moved across. We were there, then Ansley, and now over
Here in
closer to
Fulton
kids'
since
school.
2018.
Okay.
And then I worked in Carroll County.
the children's school, the kids.
No, where my kids go to school.
West.
Yeah,
Mhm.
Okay. Kind of biology.
you bet. Same.
It's like right on
Be
the
well.
rim line.
Thank you.
Oh,
Glad you're mobile.
Yeah, it's way over. Yeah, Billerica.
Well, you're mobile enough.
Billerica,
Thank you, Ms. Clark.
part of,
It's good seeing you. How goes your caseload?
yeah,
I've heard
it's,
of it.
yeah, it's on the,
Yeah,
on the country.
I know. It's weird. It's all really of our
Nice to meet you.
specialized unit. I mean, Ms. Nix has most of the cases, and then Ms. Willingham. I
Okay.
think with Ms. Marsh, or you have Ms. Marsh. Yeah, so Ms. Marsh had so few cases, so that's you.
Was it in here?
And Mr.
Okay.
Jordan
There's
doesn't
like a
have many.
random
It's
laptop
odd.
charger. Right
But
here.
I'm not complaining, because those are icky, messy ones.
Is that all from it? Nuh-uh. Oh my God.
All right. We can go back. What about Hines? Can we do, how are they both Ms. Woods cases? All right, let me see what else we've got this afternoon. All right, I got something at 2:30, but I can be a little late for that.
So just one more out.
Hey, Deputy Gordon, would you mind? I'm sorry to interrupt.
No, how are you, Judge?
How are you? Thanks for being here. Have things, how many juries ended up going out? I know there were going to be a million, but like Judge Richardson's stuff all pled out. Newkirk ended up taking 2 pleas, both our cases, and then Emerson. Yeah. Well, it's going to happen this afternoon. He's given a proffer and pleading. And that last case, Clay, I think will be a trial, but Emerson's going to manage. So it should be getting calmer for you guys. Good.
AJ is still trying to put the jury out. Judge Mom?
Really? That's non-complex. They never have trials. That's down in HA? Oh, AJ across. Okay, I'm gonna have to go poke my head in there and see. That'd be the first non-complex trial. Can you get Ms. Wood, just poke her head out in forever?
Yes, so that's a lot of jurors.
Hey, I have a 2:30 call I have to hop on, but I'll get off it. Deputy Gordon told me you've got 1, maybe 2, please.
I have 2, please.
Great. I'm not rushing you, but we could knock out 1 for sure before this call. And then we could do the other one. You tell me how you'd like it to flow.
Okay, so I think both are probably non-negotiated since we didn't have time really to talk about Mr. Hines. And so we can just go down the calendar.
Okay, but if you two want, I mean, if you want to talk for a second, I wasn't saying you got to go right now, but we should start the first plea in the next few minutes to get it done before this call, and then I'll roll off it and we'll do plea number 2. So if you want to finish your conversation with Mr. Hines, or we'll just let Ms. Nix know where you think it's flowing, that'd be great.
Perfect, thank you, Jeff.
Thanks.
He's been in 10 months. I'm gonna ask for 2 years probation for 10 months. Okay, this is the beer bottle case.
Yeah.
So they're really picking a jury?
They're over there.
Who knows what they're doing? Okay,
Mm-hmm.
okay, interesting. That's her first day in non-complex, Judge Mao.
Okay, that's fine, and then I'll just.
That's a way to start.
And I'll ask what I told you. We're on her.
5B trial, did they go?
No, the people pled, and then Dennis Francis's guy pled. And so then he zoomed over to 1D, and the guy, I want a different lawyer. Nope, this is your lawyer. So Judge Emerson said that the jurors are reporting basically now. He sent them to lunch and then was having them come, and they're not going to get through jury selection today, but they're going to start it. But that way he'll be here all week if it doesn't plead out. But Newkirk is done. So 1A is, other than this plea, he's got to take the Salmeron plea. He's on bond. So then 1A will be down for the rest of the week. Give you a little breathing room.
The guy, Mr. Hines.
All right, so we're ready for Mr. Hines?
Yes, Judge.
Great.
I haven't made an offer on either of these.
Well, all right.
So, it's not negotiated, but, I was gonna say, 10 years probation or something like that.
Okay, you can say whatever so you get on the
Oh,
record.
podium. Yeah, I'm coming up there.
Good afternoon, Mr. Hines. How are you?
I'm fine.
Are you okay standing while we have this conversation?
Yes, sir.
Okay, great. We're going to get started in just a second. I'm going to let you get on up there.
Yes, sir.
Ms. Wood, let me know when you're ready.
I'm ready.
You're ready. And Ms. Nix, you're ready? All right, everyone's microphones are on. I'm going to keep Ms. Rivers happy. You good?
Yes.
All right, let's get on the record. This is 23 SC 191-142, State versus Curtis Hines. Mr. Hines is here in court. Good afternoon, sir.
Good evening, sir.
Good evening. Make sure you speak up. He is here in court with his lawyer, Ms. Wood. We have Ms. Nix for the state. And Mr. Hines, Ms. Wood tells me you're ready to enter a plea in your case. Is that correct?
Yes, sir.
Okay. For that to happen, Ms. Nix will put you under oath. She's going to ask you a few questions. I may have a few questions. You ready to answer those questions?
Yes, sir.
Okay. Will you please tell me or Ms. Wood if you have any questions? If we get partway through and you're confused by something or you didn't hear it, will you make sure you tell one of us?
Yes, sir.
Great. Ms. Nix.
Thank you, Judge. Mr. Hines, please raise your right hand. That's your left hand.
Yeah.
Okay. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Curtis Demetrius Hines.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
59.
How far did you go in school?
Graduated.
Graduated high school, college,
High school.
medical school, high school.
High school.
All right.
Is English your native or dominant language?
Yes, English.
Do you understand that you've been charged with the following offenses? Count 1 is aggravated assault.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
I already discussed it with.
Okay. Do you need any more? I'm glad you guys talked about it. Do you need any more time to talk about it? Or are you good?
I'm good, sir.
Okay.
Are you satisfied with her services?
Yes.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Hines, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you're entering a plea that is called a non-negotiated plea and that the state may recommend a sentence to the court even without your having agreed to it in advance?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if the court enters a sentence that is greater than what your counsel, Ms. Wood, recommends to the court, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 10 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charge of aggravated assault in indictment number 23 SC 191142?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and since this is a felony, you have only 4 years from today to do so.
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about May 2nd of 2023, while in Atlanta, which is in Fulton County, the defendant and the victim, as well as another individual, were riding in a vehicle. The defendant, Mr. Hines, struck Ryan Davis from behind and causing a argument to ensue. The two individuals then exited the vehicle, and Mr. Hines swung a beer bottle at Mr. Davis's face. The beer bottle broke on Mr. Davis's face, causing him to suffer a laceration and bleeding profusely. And that occurred in Fulton County. The defendant does have 6 prior felonies, ranging back from 1987 all the way to the most recent one was March of 2023. That was here in Fulton County. That was a guilty plea from a 2019 indictment, and that was for possession of a firearm by a convicted felon. He also has a prior aggravated assault from 2000 here in Fulton County, and that one involved a firearm because he was also charged with possession of a firearm by a convicted felon. Nothing further from the state.
All right, thank you. Good afternoon, Ms. Jackson. Can you share with me your criminal history information for Mr. Hines?
Yes, Your Honor. He has 27 cycles. The last arrest was November the 28th, 2022 in Fulton County for criminal trespassing, a DUI, and possession of a firearm by a convicted felon. He does appear to be on probation in Fulton County for possession of a firearm by a convicted felon. That case number is 19 SC 16. I apologize, Your Honor. It's 19 SC 168709 for possession of a firearm by a convicted felon. That disposition date was March the 3rd, 2023. The term is for 1 year and 269 days on probation. He does have prior felony convictions. There was one in 2012 for possession of a cocaine, and one in 2002 out of Clayton County for burglary, and one in 2000 for possession of a firearm by a convicted felon and aggravated assault, one in 1997 for possession of controlled substance, one in 1987 for dangerous drugs. And he does have misdemeanor sentences and a conviction. It's one in 2012 out of Clayton County. He received a nolo contendere sentence for possession of marijuana less than an ounce, and one in 1991 for a DUI. Nothing in addition, Your Honor.
Thank you. Officer Tucson, or Ms. Tucson, it sounds like Mr. Hines is still on probation for that 19 SC case. How much time remains?
Actually, it ended March 5th. March 5th, 2024.
Got it.
Expired.
Okay, so it was about 2 years-ish, if he was sentenced in March of 20, well, less than, anyway, it's ended. Either way,
Yes,
there's
that's
nothing
correct.
to revoke.
No, there's nothing, he's not on active probation right now.
Got it. Okay, thank you. Then it's your turn, Ms. Wood.
Thank you, Judge. Mr. Hines is 59 years old. He's a lifelong resident of the Atlanta area. He is a Carver High School graduate. He has family here. He plans on returning to live with his mother. I did provide that information to Ms. Tucson. Judge, he is disabled, and as you can tell, he does suffer some physical ailments. Judge, he's been in custody since May the 3rd of last year, so 321 days. I'm asking the court for a sentence of 2 years on probation to serve the first 10 months in custody. Judge, this case, the perfect world, this would be a misdemeanor. There's a witness to the event who did not corroborate the complaining witness's version of the events. But again, I suspect if we waited for a trial, we might get into that. But Mr. Hines is eager to put this behind him and get back out into society, Judge. So I would just ask for a sentence of 2 years probation, serve 10 months. We're fine with a stay away from the alleged victim as well, Judge.
Okay. Ms. Nix, I got the factual basis and other things, but your recommendation was?
10 serve 1, no contact.
Got it. Okay, this the 10 serve 1 part, but the stay away or no contact with Mr. Davis.
I don't believe that there's restitution here, but I've not been able to confirm that. So if we could just leave that open.
Well, what it will do is I'll sentence Mr. Hines today. We can always reopen it if you contact Mr. Davis and he presents medical bills, et cetera, and we need to have a hearing. We can certainly do that. Always open to that. Ms. Wood, based on your interaction with Mr. Hines, do you see value to a special condition of either mental health evaluation and treatment if recommended, and or drug and alcohol abuse evaluation and treatment if recommended? And I'm asking that, and I'll talk to Mr. Hines about it. That's not meant to be punitive. I'm just looking at a couple of his recent arrests, a trespass with DUI, and some of these offenses. I don't know if it was people have been drinking too much and they got angry at each other and someone got whacked with a beer bottle, or if it was Mr. Davis was perceived to be a threat that maybe he wasn't because of mental health issue. But I'd like to set up Mr. Hines for a better chance of success. You're going to be 60 soon, and it would be great if you never have to wear that outfit again. You can wear street clothes. Which, if either of those, would be most helpful?
Judge, I think maybe substance abuse evaluation.
Okay.
It would be more beneficial than.
So, Mr. Hines, I'm asking you this just sort of person to person. Want you to be honest. It's not going to get you into any more trouble. It's in fact designed to keep you out of trouble in the future. Have you, in the last few years, been someone who either uses drugs or drinks too much, and so sometimes that's what's going on here?
Drink too much.
Drink too much? What do you like to drink? Whatever you can get your hands on, or is it beer, or is it?
Yeah.
What?
Alcohol.
Alcohol. Okay. All right. So, Mr. Hines, here's what I'm going to do. Well, I'm not there yet. I need to ask you, is there anything you want to share with me? You're fine? Okay. Was Mr. Davis, this is the guy who you supposedly hit with the beer bottle, was that a friend of yours? Was it a stranger or?
Stranger.
Stranger? What were you guys doing in the same car together?
I was getting a ride with one of my friends.
So you knew someone in the car, you didn't know this guy?
Right.
Okay, and you and Mr. Davis just started having words?
Argument.
Okay, same thing, had an argument. That's a better way of putting it. All right, well, I appreciate you sharing that. And you, when you get out, are gonna stay with your mom?
Yes.
Okay, the address that I've got for you is on Marcy Street. Is that where your mom lives?
Yes.
Okay, that's a safe place for you to be?
Yes, sir.
And how old's your mom?
She's 70.
Okay, and she's willing to have you come back?
Yes.
All right, well, good. Do you have any questions for me?
No, sir.
All right. Well, Mr. Hines, I find there's a factual basis for your plea, meaning the state could convince a jury beyond a reasonable doubt that you did this thing to Mr. Davis. I also find that your plea is knowing. That means you've understood things. And if you didn't, you kind of nudged your lawyer and she explained it. Do you have any questions of me about anything we've talked about?
No, sir.
Okay. And that your plea is voluntary, meaning no one's forcing you to do this, but you've decided, you know what? It's just, let's work this thing out. And I'm going to throw up my recommendation through my lawyer, prosecutor's making hers, and we're going to take it from there. Is anyone forced you to enter this plea?
No, sir.
Okay. All right. I'm sentencing you pursuant to the Probation Options Management Act. That's a big way of saying if you have a little problem on probation, you and probation will work through that. You don't have to come see me. But if you get arrested again or there's something real serious going on, that comes back to me. Okay. Ms. Wood, do you authorize someone on my staff to sign the indictment indicating Mr. Hines' guilty plea?
Yes, Judge.
Ms. Nix?
Yes, sir.
And Mr. Hines, is it okay if we sign your name on there saying guilty to aggravated assault?
Yes, sir.
All right, we'll do that. And you're telling me that right now you're not taking any medication. They're not giving you any medication at the jail?
My high blood pressure meds.
High blood pressure meds. Okay. And there. You take that in the morning or at night?
In the morning.
In the morning. Did you get it this morning?
Yes.
Okay. And does taking that make you sleepy or confused or anything?
No, sir.
No. All right. And you're not on probation right now. So here is what I'm going to do. I'm going to sentence you, Mr. Hines, to 5 years to serve 11 months with the balance on probation. Now you are about 8 days away from 11 months. So you're going to get out in the next few days. And then you're going to be on probation for 4 years and 1 month. While you're on probation, 2 special conditions. Number 1, you have no contact with Mr. Davis. That should be pretty easy because that's not someone you're normally spending time with. But if you see him, just turn around, go the other way. Number 2, you're going to need to have an evaluation with a professional about any drug or alcohol abuse. You don't have to find that person. Probation's going to help you do that. You'll have an appointment. That person's going to ask you a bunch of questions about what you drink and when and why and all that. If there's any treatment that's recommended, that treatment becomes part of your probation. So just as an example, if that doctor or counselor who talks to you said, you know what, Mr. Hines needs to go to some AA meetings. Guess what? That's part of your probation. You got to go to AA meetings. Did you say, Ms. Wood, that Mr. Hines is disabled? And if so, is he on disability or he hopes to get onto disability?
I'm on disability.
You're on disability. Okay. Then I'm going to waive your probation supervision fees. Doesn't make any sense to take government money to pay the government. So you won't need to pay those. But you do need to report to probation and call your probation officer or take his or her calls and all that kind of stuff. Do you have any questions about anything that I said?
And how much probation will I have on?
4 years and 1 month. Okay. The state's recommendation was basically 9 years probation, 1 year to serve followed by 9 years probation. Your lawyer was saying, how about time served followed by some probation? And I'm somewhere in the middle there. Now, 2 things. 1, Ms. Nix, anything you want to add to what I just said as to the sentence?
Yes, sir.
Mr. Hines, the sentence that I imposed is a little higher than what Ms. Wood asked for. And so if you don't like that and would rather wait and go to trial, we can do that. You've got the right today to say, no, thank you. I'd rather go to trial and maybe it'll go well for me. If it doesn't, that could be worse. Who knows? But you're probably going to stay put until we have that trial. Do you want to talk with Ms. Wood for a minute, or do you know you want to go forward with the plea?
I'm going to go forward.
Okay. Well done. Last thing then, Ms. Tucson, who is on this call, is with probation, and she's going to ask you a couple questions and give you reporting instructions. And Ms. Wood's going to write that stuff down for you so you don't have to memorize all of it. Okay? All right. Ms. Tucson.
Okay, thank you. I do have the email from Ms. Wood, so I appreciate that. Do you know, Mr. Hines, where probation is?
Yes.
Tell me where you think it is.
You're right down the street from here.
It is right down the street from here. Okay.
Would I be able to call, who, is it your mom's number?
Yes.
I gave her, okay, that's what I gave her.
Okay, so I will call them with the reporting instructions, and I have the address here on Marcy Street.
Yes.
And the number 678-334-0300 or 404-797-8229.
Oh, and I have a third one I'm gonna give you, Ms. Tucson, 404
Uh-huh.
857 5553.
That's the one.
That's the right one, okay.
And this is for mom?
Yes, Anita Hall.
Okay, so we'll call you with reporting instructions, so you can report within about 10 days, Mr. Hines, or I'll give you a reporting date, okay?
Yes, ma'am.
Okay.
Mr. Hines, I wish you luck. You still got a lot of years ahead of you. I'm hoping maybe if you get some help with the drinking and your mom's looking out for you, if I bump into you, it'll be out there and not in here, okay?
Yes, sir.
All right, good luck.
Yes, sir.
Thank you, Judge. Mr. Hines, this is the paperwork. Do you have a pocket? You can put it in, don't lose that.
So for everyone on the Zoom, we're gonna take a break until 3 o'clock. And when we come back at 3, we will take Ms. Recky. Did I pronounce that correctly? She'll tell us,
Yes.
but Ms. R's plea. I gotta hop on a Zoom for 30 minutes about a super exciting CLE you all could attend. I think it's next Thursday or something, but then I'll be back, and 3 o'clock we'll do that plea. Okay, thanks. And I will mute the microphone in here so you can speak freely.
Thank
All right, we are back. Are we ready for Ms. R?
Yes, yes, Judge.
Great.
I think it's Ricky, but I'm not positive, so.
All right, well,
Tell us.
I'll ask her to pronounce it. Ms. Rivers, are you ready to go?
Yes, Judge, I'm ready.
Great. If we could bring the defendant out, please.
My daughter says
We ready,
hello.
Flo?
Your daughter what?
She says hello to you, Judge.
Oh, hey daughter, how are you? Good. Happy day after St. Patrick's Day.
Yes.
There, slide over a little more. Ms. Wood's gonna stand, there you go. You're right there.
Hey.
You can see yourself.
Did you find this green kid?
I found the address.
What did he say?
Can you pronounce your last name?
Ricky.
All right. Are you ready to go, Ms. Nix?
Yes, sir.
Ms. Wood?
Yes, sir.
All right, we'll get on the record in 23 SC 190994, State versus Recchi. Ms. Recchi is here in court with her lawyer, Ms. Wood. Ms. Nix is here for the state. And Ms. Recchi, Ms. Wood tells me you are prepared to enter a plea in your case. Is that right?
Yes, sir.
Great. Ms. Nix, is this a negotiated plea?
Yes, sir.
So Ms. Recchi, and the way this is going to work, in a moment, Ms. Nix will put you under oath, and then she's going to ask you some questions. I'll have some questions too. You'll need to answer those truthfully and fully. At the end of all this, Ms. Wood is going to recommend a sentence for you, and I'm guessing she's told you what it was. I don't know what it is. I'll know in a minute. I'm going to make it up. She's going to say 2 years probation. Ms. Nix is going to recommend a sentence as well. It's going to be different, and it's going to be more severe. I have to decide what the sentence is, and it might not be either one of them. It might be something in between. It might be less. It might be more. But you have the ability to say, no, thank you, Judge. If the sentence I impose is in any material way more severe than what Ms. Wood asked for. So if she recommends 2 years probation and I say 5 years probation, you'll get a chance to talk about it with Ms. Wood and say, hey, you know, that's not great, but I'll take it because I get out. If I say 5 years in prison, you'll have the ability to say, oh, not so fast. I'd rather have a trial than 5 years in prison. So you'll get a chance to process the sentence that I impose, unless it is exactly what your lawyer asked for or less, and then you're stuck with it. Does that make sense?
Yes.
Okay, good. Then let's have Ms. Nix get us started.
Judge, Ms. Recchi, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matters currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your true, correct, and legal name.
Ma'am?
Please state your true, correct, and legal name.
Tamara Shante Jackson Ricky.
Please spell your name for the court reporter.
TOMORASHANTERJACKSONREKHI.
Are you also known as Tamara, Tamara? Recchi?
This is just a misspell.
Okay.
But we're talking about the same person. You're not saying, you're not confused why you're here as opposed to your twin sister or someone.
Yeah.
Okay.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
That's about mental medication.
You say your mental medication?
Yes, ma'am.
How does that affect your ability to understand this proceeding?
Neither.
I'm gonna ask you.
No kind of way.
No kind of way?
Like you understand what's happening, correct?
Yeah.
Yep. Okay. Tell me, what do you take medication for? What you've been diagnosed with?
Paranoid schizophrenia.
Okay. And you don't need to list all the medications you take. Tell me how often you take them. Do you get them in the morning or at night?
I take a set every morning and a set for lunch, for dinner, lunch and dinner.
Okay.
That's it.
Did you get medication this morning?
Yes, sir.
And when you take it, does it make it easier for you to understand what's going on, or does it knock you out?
No, it makes things easier, smoother day.
Great. Okay. And is that how you're feeling right now? It's a smoother day?
Yeah.
Good. Ms. Nix?
Is there medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
43,
How far have you gone in school?
13,
Does that mean you did some college?
some college.
Okay.
Is English your native or dominant language?
Yes, ma'am.
You understand that you've been charged with the following offense: aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea, including those with regard to your client's name?
So wait.
Ms. Recky, do you remember having been arrested on this charge?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
You understand that your plea of guilt today is called a non-negotiated plea, and the state may recommend a sentence to the court even without your having agreed to it in advance?
Yes.
You understand that the court can impose any sentence authorized by law, including a higher sentence than that which is recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
You understand that if the court decides to order a sentence that differs from the sentence that your lawyer requests, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am. Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right
Yes.
to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yeah.
How do you plead to the charge of aggravated assault in indictment number 23 SC 190994?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and since this is a felony, you have only 4 years from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about October 30th of 2023, the defendant, Tamara Recky, used a pocket knife and made a poking motion and a swiping motion at Clark Bennett. The knife is one which is, when used offensively against a person, is likely to result in bodily injury. And this occurred in Atlanta, which is in Fulton County.
Did you say, I know you said Atlanta, we know where?
It's 60 Lucky Street.
Lucky Street, so near here. Okay. All right. Anything else?
The state will recommend a 10 serve 1. In this case, the defendant has 2 prior felonies. Neither are in Fulton County. One is theft by shoplifting and another is aggravated assault. The most recent one is felony is 2010.
Is that the aggravated assault?
Yes.
Okay. And is it a Georgia felony or?
Yes, that's in Muskogee County.
All right.
There is also a aggravated assault she was arrested for in 2022, but that had been dismissed at prelim prior to this incident.
Okay. Got it. Thank you. Ms. Jackson, do you have any additional criminal history information?
Not that I know of.
Nope, not you. Someone on the screen. You're Ms. Recky.
Just has misdemeanor convictions, Your Honor.
Okay, how many total cycles?
21 cycles.
Okay, and all misdemeanor situations or arrests that did not result in any final dispositions other than the 2 felony convictions that I heard about?
Correct, Your Honor.
Okay, and what's the most recent arrest you've got?
October the 23rd, 2022, with the City of Atlanta Police Department for aggravated assault and battery. That charge was dismissed on May the 25th, 2023.
Thank you. I appreciate it. That's our last case for the day, so you are free to go. Thanks for joining us both this morning and this afternoon.
Thank you, Judge.
You bet. Ms. Wood.
Thank you, Judge. I'm asking the court to consider a sentence of 3 years probation, served 140 days in custody. That's what she's done so far. I'm also asking for a mental health officer to be assigned. Judge, she's a lifelong Georgia resident. She has family down in the Columbus area. She's also got some family on the other side of the state line in Phoenix City. She's hopeful that once she gets back stabilized, she'll be able to reconnect with that family. Her children are down there, so that's what's important to her. Judge, she is a high school graduate. She currently was receiving disability. I'm sure she has to get reestablished with that. Judge, our social worker worked with Miss Ricky to look at some different options. It is her desire to return to a group home on 1385 Sharon Street here in Atlanta, since that is a probably quicker way to get out than wait on the programs that accept Our Lady clients, Judge. This incident stems from her going through a little bout of homelessness. The other gentleman, it's my understanding, was also unhoused at the time. It was a dispute over something very minor, I do believe. So I'm asking, there were no injuries also. I'm just asking for 3 years to serve 140 days, Judge.
Okay. Ms. Recky, you have family, including children of your own, that are down in Columbus and Phoenix City?
Yes, sir.
Okay. But you'd like to live in the Atlanta area, at least initially?
Yes, sir.
When would you then go down to Columbus?
I'm not sure, sir.
Okay. How old are your kids?
18 and 10 and 1.
10 and 1. Who takes care of the 10-year-old and the 1-year-old?
My stepfather, my dad.
Okay. And the 18-year-old is a boy or a girl?
A boy.
Is he done with school now or still in school?
He's finished with school.
What's he doing now?
He works at a hotel.
In Columbus?
Yes, sir.
Okay. And your stepdad's taking care of the other 2. Got it.
Except for my 1-year-old. My 1-year-old just got adopted.
Oh, was adopted by someone?
My stepsister.
Okay.
Through Atlanta by Prior Street Court.
Got it. But it's adopted by a relative, so you'll be able to see your 1-year-old. It wasn't a family in Arizona, and you won't see. Okay. Well, I'm happy for the little one. Hopefully that'll be a good household. Mr. Bennett is the name of the guy that you supposedly were swinging the knife at. Is that someone who was living where you were living? Is that a stranger to you?
I think he was following me because I had got the thing out the trash can.
Okay.
And I think he was just picking me.
But he's a stranger to you, not
He's
some.
a stranger.
Okay, that's all I'm getting at. Because if he was a friend, you guys are going to need to stay away from each other. Sounds like if you bumped into this guy again, it would be purely coincidental.
I don't know.
Okay.
So when you don't have any issue, stay away.
Yep. All right, let me check one thing. So the Sharon Street address that Ms. Wood mentioned, that's a group home where you had been staying?
Yes, sir.
How do you know that they have space for you when you get out?
Because they always have beds open.
Well, I like places like that. I didn't know something like that existed. I mean, places are always full.
She's always open and
Okay.
manageable.
And how do you pay for that? You get your benefits?
Social Security.
Okay. And are you still getting your benefits? Have they been cut off?
I'm not sure.
Okay. Do those flow directly to you or through a relative?
I don't have no priority. No priority. Nobody taking care of me.
Okay. How do you go about turning the benefits back on?
I'm after my dad, my father. I called him and told him already.
Okay. And he'll help you get them going again?
Yes, sir.
All right. Where do you go to get your medication when you're not in jail?
Grady Hospital,
Okay. At Park Place or Grady, the main hospital?
the main one. Either one, I think.
Either one. Do you have a Grady card?
I haven't got one yet.
Well, when you walk into Grady, how do they?
I just tell them I get Medicaid through Social Security.
Yeah. And they can look it up. Okay.
And they give me medicine.
All right. Hope it's the right medicine.
Oh, that's right.
Did you find that the medicine that you're taking at jail right now works better, worse, or the same as the medicine you get when you're going through Grady?
Well, I kind of feel like it's the same.
Okay.
It's kind of the same. It's just some pills be different colors, but they're supposed to be the same.
Okay. And you know, it could be a generic versus not. Who knows? All right. Well, Ms. Recchi, do you have any questions about anything anyone has said today?
Well, I know I can't be digging in the trash. I was digging in the trash. And
Probably a good rule in life.
And I wasn't trying no harm intended. I was just looking for some shoes.
Okay.
And the guy, he left his shoes.
Huh?
He left his shoes in the trash.
All right.
And his name was on papers. So I don't understand how this could come this far.
Well, it sounds like we're going to work it out today, so it doesn't need to go any further. Do you have any questions about anything Ms. Nick said or anything I have said?
No, sir.
All right. Well, Ms. Recchi, I find that there's a factual basis for your plea, meaning the state, if there was a jury here, could convince them that this happened. I also find that your plea is voluntary. That means no one's forcing you to enter this plea, but you've decided this is how you want to move forward. Is that correct?
Yes, sir.
Okay. No one's threatened you in any way?
No, sir.
All right. I'm also finding that your plea is knowing, meaning you've understood what we talked about. And I think that's right because you've told me you don't have any questions. You feel like you've understood what we've discussed?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that while you're on probation, which you will be for a little while, if you have a little problem with probation, maybe you miss some meetings, you and probation will figure out what to do about that. But if it's a bigger deal, you get arrested again, you've got a knife or a gun or whatever, that comes back to me and we'll figure out what ought to happen. Okay? Yes?
Yes, sir.
All right. Ms. Wood, can someone from my office sign the indictment on your behalf?
Yes.
Ms. Nix?
Yes, sir.
And Ms. Recchi, is it okay if we put your name on the indictment indicating your plea to this case?
Yes, sir.
We will do just that. So, Ms. Recchi, what I'm going to do is sentence you in this case to 5 years to serve 5 months with a balance on probation. So you are about 6 days short of 5 months, and then you will have served that. But you're going to get credit for all the time you served. And my guess is you get out tomorrow or the next day, this week. So you get out this week, then you'll be on probation. Special condition of probation number 1 is that you continue to take all medication that doctors prescribe. So you mentioned the pills are different colors. You may want a pink one, but if they're giving you a green one, you take the green one, okay? If the doctor says this is what you need to take for the paranoid schizophrenia, you take them. Understand?
Yes, sir.
Number 2, you need to stay away from that gentleman we've been talking about, Mr. Bennett. I know he's a stranger to you, but if you are walking down the street and you see that guy, you turn around and walk the other direction.
Right.
Okay? I'm going to request that probation assign to you what we call a mental health probation officer. That's someone who knows real well how Grady works and will be making sure you're taking the right medication and will be more sensitive to the needs you've got because of the medicine you're taking. I'm also going to waive your probation supervision fees because if you get benefits, we're going to have those benefits focused on you getting housing and food and whatnot and not paying probation supervision fees. I think that's it. Were there any other conditions you had asked for or wanted to see, Ms. Nix?
No, sir.
Okay. Anything else, Ms. Wood?
No, Your Honor.
All right. So Ms. Recchi, you and Ms. Wood should talk for a minute because she asked for a sentence that involved a little less probation, but I'm giving you a little bit more just because I want to make sure we get you stable back on medicines outside of the jail. And if you decide to move down to Columbus, that we've got probation can be transferred down there. That's not a problem. You need to let people know you're moving. Don't just zoom on down there, but you tell your probation officer, you know what, I'm going to go live with my dad or whoever else is down there. Then we just shift supervision from Fulton County to Muskogee County, as long as you tell people what's going on, okay?
Okay.
Do you have any questions about the sentence that I just described?
I got 5 years probation.
Well, it's less than 5 because you subtract all those months that you've served, and I said 5 months. And so it's going to technically be, if you're doing the math, 4 years and 7 months of probation.
Okay.
Okay?
Yeah.
Okay.
What about the whole jury? What about the whole?
Okay, so I'll let him know about that, but otherwise you're good with the plea. Okay, Judge, she's good with accepting that. She's very concerned. I informed her that the booking screen is showing she has a hold for the city of Atlanta. She doesn't think that's valid. I informed her sometimes it may be a mistake, but that they'll be able to let her know about that once they do the booking process.
Right. So this week, they're going to process you out. And if you do bump into a hold, just let Ms. Wood know. And if it's something that I can address, I will do that. If it means you need to get to state court or municipal court, that's where we're going to get you because you've cleared up this situation. And then whatever's next in line, which may be this hold, then you'll be able to address that. Okay. So you won't get stuck. It'll just mean now it's time to go to that other court. Ms. Tucson, what do you need to share with Ms. Recchi?
What do I go to that house on Sharon Street?
Yeah, I'm gonna walk back here and give you this.
Okay, I was just reading over the reporting instructions for when somebody might not have stable housing. Miss Recchi, you might have to report more than usual, but your first report date, will you be able to remember April 2nd?
I'm writing it down.
So 2 things. Ms. Tucson, who works with probation, said 2 important things there. One, she's given you a reporting date when you need to show up at probation, but that's being written down. And you can always call Ms. Wood to ask her again. But 2, you may report a little more often just because the housing where you are is a little less certain to us. But that doesn't mean you go every day. It just means that you'll be checking in with probation a little bit more frequently. Okay?
Okay.
All right. What else?
They'll also give any type of tools she might need for any type of housing programs. Do you want me to give you the phone number, Ms. Wood, that's
Yes,
that she can call?
Yes, please.
404
Okay.
463 0410.
Thank you.
Okay, no problem.
Anything else?
No, Your Honor, thank you.
All right. Well, that covers everything. Thank you, Ms. Tucson, for your help today.
Thank you.
And thank you, Ms. Rivers. Good luck, Ms. Recky. I'm going to leave the Zoom open for our 4 o'clock. If there are people who are Zooming in, you are both welcome to do that. I'll come back out here at 4 and we'll talk about the trial calendar.